Yes.
Lordship, memo for posting, my lords, fresh matter. It's against writ petition, my lords, tender matter relating to tender document. The judge has misconstrued the meaning of tender document, has vacated the interim order, my lords. Matter is of urgency, my lords.
What is the
Kindly,
it can go after,
there was a status quo in my favor, my
it
lord.
can come up after holidays.
My lords.
It can come up after holidays.
No, my lords, they have proceeded with the tender procedure now. That the matter has been, there was an interim order, now it is vacated, my lords. Solely based, there was no IA for vacating stay also. Interim order has been
We'll
vacated.
post it tomorrow, day after tomorrow, but if it is not urgent, it is found not to be urgent, we'll adjourn after 3 months. Today, there are several matters, at least 3 matters, which were mentioned yesterday for urgency, in which there is no urgency.
My lords,
Absolutely, there is no urgency. If such your matter turns
this
out
is
with that,
regarding
it will go
textile,
after 3 months, mind well. So think twice before mentioning and seeking, getting it listed.
regarding textile, my
Well,
lords.
day after tomorrow. Yes.
This is a matter pertaining to forest land. They passed an order for removal and cutting and remove the trees from the forest land for the purpose of establishing a chemical industry. I have filed a writ petition, this honorable court issued a notice. Now, during the pendency of the writ petition, they have, the direction was issued to cut and remove the forest trees land.
It can come. It can afterwards.
If the trees are, I am not urgent, your lordship, this week or next week, subject to convenience of your lordship. I am not saying not tomorrow or tomorrow.
21st of October.
Because otherwise that trees are removed, there is nothing to
21st October.
One matter will.
With your lordship's kind leave, madam.
The one matter pertaining to compassionate appointment. The management has not taken a decision. I filed a writ petition before the other single judge. So seeking a direction, writ of mandamus directing to the issue a mandamus to the management to consider my case. But instead of doing it, the other single judge decide the case on merit, contrary to several judgments of the Honorable Supreme Court and this Honorable Court. But it should be decided by the management. But again at that order I preferred. Any date, I am not saying this.
29th of October.
Please, my lord, sorry.
My lord, with your lordship's kind permission, I may kindly request for assignment of a new bench.
Yes, madam.
My lord's wide order dated 6th of August, Honorable Justice M. Nagaprasanna has recused in several matters. My lord, no new bench has been assigned so far in the matter. My colleague Mr. Dhanish will pass on the memo to the court master, my lord. I am requesting for assignment of a new bench and posting of the matter accordingly, my lord.
We are not catching what you are saying, madam.
My lord, I am requesting for assignment of a new bench pursuant to Honorable Justice M. Nagaprasanna's recusal in 3 of my petitions. The memo for
here is the memo, your lordship.
You mention it, go before the register judicial and went your.
I'm representing her. This is for a recused matter. A bench has to be allotted, my lordship. She is from Delhi. My colleague is from Delhi. It is 1.5 months over, my lordship. I will be requesting for.
Is that not to be mentioned before the court? It is administrative matter. Go before register judicial.
Register judicial.
Okay.
Naturally.
Please.
Much obliged.
Contempt petitions, my lord. 8/26 of 22. My lord, filed, my lord, after 1.5 years, they filed an RP. My lord, 481 of 2023. My lord, special bench was constituted to lordship, my lord, along with it, my lord, Honorable Justice Shetty.
Again, same request. Go before register judicial.
Problem is, my lord, I have given several memos to the register judicial, my lord, bench.
Now you this memo will follow.
Any date, my lord, your lordship.
We will not fix unless register judicial is routed through the register judicial.
I have given several.
It can't be done like that.
Bench has,
It is out of procedure. It can't be done. Yes.
But
see that it is. It goes to the register judicial.
Certain lands were acquired for the purpose of establishing a golf course, my lord. My lord, the respondent number 4 is putting up construction over the roads belonging to the government where the villagers pass by, my lord, thereby preventing the villagers to pass through the lane, my lord. The matter is very urgent in nature, my lord.
After holidays.
Any date may be fixed, my lord. Any date may.
Any date? All right. 12th November. Yes.
Much obliged.
With that order, that in this, we had filed a writ of mandamus to return the original mortgage properties to the petitioner. That's we date after the litigation benefits.
11th November.
The October last week.
29th October.
Well, serial number 63, my lord.
63. What is it?
Well, I appear for the respondent. I have informed the other side also. I have to file my counter, my lord. It's an SCST
Appear
matter.
Appear
After
for the
vacation.
appellant.
63.
Yes,
So after
Appear
After
for the
vacation.
appellant in that case, my lords.
it will go
Appear
to
for the appellant. I have no objection, my lord, for adjourning the
6th
matter.
6th November.
Please.
My lord, civil contempt, my lord.
Yes.
Civil contempt, my lord.
My lord, the serial number 38, my lord. Yesterday we have received the statement objection filed by the state government. May permit me to file a rejoinder to that statement objection, my lord. 38 serial number.
11th November.
Much obliged.
Civil contempt, my lord. Any date may be fixed, my lord. Respondent authority not.
Why you are submitting memo? It will be listed before we give the date.
Any date may be fixed, my lord. 2023, my date, year, my lord.
But you remove the officer, it will be listed within a week.
Respondent authority not allot the alternative sites, my lord.
If you prefer the date to be given by the court, then it will be 12th of November. 12th November.
Chart date, my lord. Chart date, my lord.
Not, then
October
you,
first,
then you go through regular procedure.
Second week or third week, my lord.
If you go through regular procedure, it will be listed within week after you remove the office of justice. If you mention in such a manner, we'll give the date as per our convenience. So you choose the alternatives.
Next.
12th September, 12th November. Yes.
Serial-
Yes,
Serial number 55.
Yes,
Serial number
madam.
40, my lords. I appear for the petitioner in this case. May I have it after vacation because they have filed an impleading application. Then to file objection, we require some time to seek instructions from the time.
7th November.
Your Honor, WA 983 of 2024, I was given date of today for the interim relief orders to be granted. It is not on the list.
Not listed. No. Listed. When will you? Is already a date fixed. You file an application for preponement.
I have already given the memo for posting in my previous
Or will
appearance.
not do. Once the date is
No.
given by,
The date was given
date
today,
is,
24.
once the date is given by judicial order, memo will not be permitted to prepone the matter. If you want to prepone the date, file an application.
I have filed a memo for amendment of pleadings under Order 6, Rule 17 of the CPC, Your Honor.
You-
This was filed yesterday
Correct.
in order to eliminate the restrictive clause of paragraph
Whatever it,
27.
you file an separate application for preponement of the date.
That has to be a separate memo for posting, Your Honor.
Separate application. You consult
Otherwise,
some-
the interim relief orders is to
you
be
consult
granted on the
some-
24th.
You consult some advocate friend and do it, yes.
You know, there is urgency for receiving the interim relief. I would like to walk through the interim relief orders.
That may be, there may be an urgency, but we need to go on, you have to go by procedure of filing the application. Yes, everybody is doing that, every lawyer. You can't be the exception. Yes, Mr.
Serial number 98, my lord. 4 weeks time will be given to complete the office objection.
98,
8.
what do you want?
4 weeks time may be granted to complete the office objection.
4 weeks time is granted to comply with the 98, comply with the office of justice. 4 weeks time is granted to comply with the office of justice. Full stop. Serial number 98. 27, yes.
Very for the petitioner case, my lord. Serial number 57. Very for the appellant. Short accommodation can be given Monday to be because
Which one?
Number 27.
Same you are mentioning.
that I'm the appellant in this case. We already argued the matter from our side. But the, well, last occasion you had filed the,
What is it about? What is it about?
Chairman of the. Cancellation of the.
It is not argued.
on cancellation of the decree, they are benefiting now going on. Because and the AC, if ever AC orders in your.
Let it go after 22nd of October.
Shortly the time begin.
This is
Monday.
shortest.
Monday.
This is shortest. Monday. Monday will give. 21st October is Monday.
Serial number 28, my lords.
Yes.
Lords.
55.
I appear for her, in this
55.
case. In this matter, this is regarding abuse of the children. Yesterday, Honorable Supreme Court has given this judgment. Some 9 directions are issued to on this Honorable Court, all the courts. And that will have a bearing on my case. That's
Will
the
be-
number 55. And further, there is already a direction to list this matter before the conference hall of this Honorable Court, by this Honorable Court.
But we'll be taking up after vacation.
No, that's true. It has to be listed before in the conference hall. There is already a direction.
But after vacation. Today, difficult to. spare the
I
time.
agree, but anytime after vacation,
That
that is the
will-
conference hall.
That will give 22nd October.
Please,
Serial number 28, my lords. Lords, in this matter, I appear for the appellant, arguing counsel that it would undertake travel on an emergency basis. My lords, may kindly list the matter after vacations, my lords.
After vacation, 10th, 13th November.
Please, my lords.
My lord, serial number 22, my lords. There's some inconvenience for the arguing counsel today, my
Time?
lords. Yes, ma'am. Short accommodation, my lords. 22.
Choose your date. Which date?
Any date as per
Any
your
date.
lordship's convenience.
28th October.
Obliged.
Serial number 96, my lord.
Bill number
96, my lord.
96. Yes.
2 weeks' time may be granted, my lord, for complying to office objection.
What is it about?
Pardon, my lord?
What is it about? What is the subject matter?
My lord, matter is regarding one school, my lord. The school is running illegally by encroaching stormwater dredge. You had initially filed a writ petition, it has been now been converted into PAL, my lord.
29th October.
Please, my lord.
Send out to 29th October. The office of objection shall be removed before the next day. Serial 196.
My lord, serial number 104,
10?
4.
10.
Non-compliance of office objections, 1 week time may be granted. my lord.
10?
4. There are 2 office objections.
What do you want?
1 week's time.
It will go to 21st October.
Thank you.
This new writ petition, fresh matter. This is also connected with the same cause of action. However, the subsequent steps involved in the remedy of the cause of action, it's WP 24623 of 24. I would need about 30 minutes of hearing time to present this writ petition to the Honorable Court.
Or like post it on 25th of October.
25th of
October.
October.
After holidays, yes.
List number 2, seal number 1.
Kindly pass it out.
To
Lord.
Prasanna
Yes, senior
Deshpande.
counsel is on his way, he's on his legs.
This matter, we pass it, passed over.
It is not possible to take.
My
up.
lord,
Lord, because end
we
of
have to
this,
file a
my lord,
counter.
because he's coming for serial number 6, my lord. On his way, my
Pray
lord.
for some
Like-
time to file our objections. Objections have to be filed.
File your objections.
Please, my lord, we'll file.
Objections shall be
My lord, we
filed.
are pressing for interim order, my lord, because counseling is scheduled on 26th. We have engaged senior counsel. Last date of hearing, he argued, my lord. Kindly have it, my lord. After 10 minutes, will it'll be on.
Called out, but
Sorry, my lord.
it is called out. The court can't function at your convenience.
No,
at your
sorry,
time. Keep back.
sorry.
This is no way to tell that serial number 6, the council is coming.
No,
This
no,
is
no,
number
he's on
1.
he's on his legs, my lord.
Court can't function at
I
your
am-
convenience and your time and
I am
your
up-
serial numbers.
I apologize.
Just keep back.
Seal number 2, Mr. Ajay N.
Yes.
For the appellant.
This is a case where the students have cleared the need. They become part of the respondent number 3 university.
What is the urgency?
The urgency is tomorrow is the last date for paying the examination fees for the third year, my lords. It is in
But
page
this is
number.
the matter where earlier petition was filed and you have failed.
Please, my lords. The earlier petition was dismissed, my lords. So prior to that, there was another petition where the division bench had also passed an order, my lords.
Where is
My
the,
lords,
where
there
is
is pari-
where is the earlier petition?
There are two other judgments that are passed.
Don't come here. Be there.
On the basis of parity, there are two other judgments passed by the single judge, my lord.
Where is the earlier petition on the basis of it? This petition is dismissed.
Yes, my lord.
Where is that?
My lords, I've given it.
In this one. So it was filed by whom?
It was filed by the college, my lords, respondent number 3 in this case. The first writ petition is the earlier judgment. My lords, but I was not aware of the college filing on my behalf.
Not your own behalf. What can be done? You have challenged that order.
My lords?
You challenged the order passed in the college's petition.
Yes, my lords, we have filed another writ petition subsequent to the one which we had initiated in the first.
The order in the earlier writ petition, which is by learned single judge, not natural.
Now we have challenged that order.
But what prompted the college to file?
That we are not aware, my lords. Initially, when we joined the college, we were not even aware that
You are the petitioners.
I'm for the petition. I'm for the appellant, my lords.
No, in that petition, you were.
In that petition, college was the main petitioner, my lords.
You were also.
I was also party to it.
Party or petitioner?
I was the petitioner, my lords. But I was not aware of the entire proceedings because.
But then the remedy is not to file another petition. The remedy is to challenge that order.
My lords, we were not aware of the first petition that was filed by the college, my lords. We've
File
also
a-
given that admission in the writ
File a
petition.
review. File a review.
Please. My lords, but directions.
Even
can
if
be-
we want to help you, it is not possible.
My lords, but that happens to be a division bench judgment. So the single judge order,
Pardon?
the first petition was a division bench judgment.
Correct.
So this
Therefore-
happens to be a single,
Therefore, initially we said that file a appeal, but now having seen that it is division bench order, you file a review.
review before the single judge.
Division bench.
Please, my lord.
The
My lords, at least direction.
writ petition number
But I can pay the fees.
12902. Full stop. Realizing that the judgment and order dated 7th September 22 passed in common in writ petition number 12902 of 22 and in writ petition number 12946 of 22 by the coordinate bench would come in way in agitating the grievance from a learned advocate for the petitioner, Mr. So-and-so, seeks permission to withdraw the present petition. He further states that the petitioner would opt to approach the bench by moving in review petition to such permission is granted. However, the court has not gone into merits or has not expressed any opinion on the merits on the subject matter as well as in respect of the recourse to review application.
Well, but tomorrow happens,
What is observed is that if the issue of limitation arises in filing the review application, the time consumed in prosecuting the present writ appeal shall be treated as bona fide litigating.
well, but tomorrow happens to be the last day for filing. Well, next month is the examination, my lords. I would not be able to take up the examination as well, my lords.
Not possible. In vehicle, we can't take a different view.
My lords, there is parity basis, my lords. The very same single judge has also given other students to enter the second and the third judgment is on the very same basis, my lords.
Pardon?
The second and the third judgment that is given by the honorable
Then
judge.
you said that you are going to file review. Now you are backing out.
My lords, parity on the basis of
Said
parity.
what, you said, what do you want to do? You want to pursue with this,
My lords, will pursue with the same case only.
then the order will be same.
My lords, but there is parity, my lords. I mean, there are other students who have also been given the opportunity to continue with the education, but in my case, because of the division bench order, I'm not able to continue with my education. ma'am.
So unless you really, you get the order reviewed, we can't take a different. You are bound by the precedential value and the relief denied to you. In the identical subject matter, in a petition, where your party is rightly or wrongly to your knowledge or without your knowledge with college. So our hands are bound. Even if we want to help you, it is not possible unless you do a review opinion. What do you want this order?
I'll apply for a review petition.
Same.
Please, ma'am.
Still number 3, A.V. Gangadharappa.
Appear for the appellants. We are the existing tenants of the shops constructed by the municipality from 1975.
No, this is the matter you mentioned it.
Yes,
yesterday,
yes,
for placing it urgently
yes.
today, and we
Please.
placed it in a separate board, accepting your plea that it is urgent. What is the urgency? Tell us.
Urgency is this: day after tomorrow, that is on 26th, auction will be held.
Where is that auction notice?
Annexure H. Kindly turn to page 66. Annexure H at page 66. 26/9/2024 at 11 AM.
Where is the order of single judge? Where is the order of learned single judge which you
Please.
tell me?
Learned single judge orders is Learned counsel for the respondent seeks time to file statement of objections at page 15. 2 weeks' time is granted to file statement of objection. Auction proceedings shall be subject to the outcome of the writ petition.
So in your page 15 of your compilation.
Now, my submission before this honorable court is this. We have been given the right of first refusal. The option is
15.
given. Page 15 I am reading. We have been given,
Page 15.
please, not in the order passed by the learned single judge, but in the notification, we have been given the right of first refusal.
You are challenging this order.
Yes, I am challenging this order passed by the learned single judge.
Read the order.
I will read once again. Learned counsel for the respondents seeks time to file statement of objections. 2 weeks' time is granted to file statement of objections. Auction proceeding shall be subject to the outcome of the writ petition.
You are protected to the extent you can be protected.
Now, my submission is only start submission I would like to make. Under the proclamation, this notification itself, we have been given the option of making an application under the right of first refusal. We did, as could be seen, I am producing the copy of the application along with the endorsement that has now been issued.
Learned single judge protect your interest by saying that the auction will be subject to outcome of the petition.
Now, we are going to be evicted.
Go before learned.
We are going to be evicted because the municipality in the endorsement, they say, which we have received yesterday.
Go before learned single judge for modification, addition of the interim.
Now, day after tomorrow is the auction.
We can't help.
In fact, I pleaded before the learned single judge that this is the position and we have got the right of first option. We have been even denied that right of first refusal also on account of the fact the shops that which we are carrying on.
Are you arguing against the order or are you arguing against learned single judge?
I am submitting before this honorable court. I am
We are not
submitting,
entertaining the
I am
appeal
submitting before this honorable court that even the right of first refusal is also refused by the municipality, stating that these shops are reserved for persons belonging to scheduled caste and scheduled tribes.
Sorry, heard learned.
May I place the endorsement that has been issued by the municipality?
Are you place? Whatever you want to place, we are welcome to place.
Madam.
Right.
Kindly see the endorsement that has been issued by the municipality. In fact, at page 4, we made an application under the right of first refusal. Page 4. Then the endorsement is at page 7. May I read to the Honorable Court? Referring to the above subject as per circular referred to at 1 above, regarding the disposal of 34 shops in the first phase situated in New Bus Stand as per circular of the government, approval is obtained from Deputy Commissioner and auction notification is issued. As per the said notification, you have submitted representation referred to at 2 above, exercising the right of first refusal. However, as per government circular referred to 1 above and annexure 3, serial number 11, 18% of the shops have been reserved for persons belonging to scheduled caste and scheduled tribes, and it is specified that the reserved shop shall be disposed of through public auction only to persons belonging to scheduled caste and scheduled tribes. Hence, you are informed that there is no question of right of first refusal. And in case you intend to take the shops on lease, the shops meant for general category can be taken by participating in the public auction. Accordingly, our application is hereby disposed of at this stage itself. This is the endorsement and which we received yesterday, stating that we are neither permitted to take part in the auction and we are also prevented from exercising our right of first refusal.
Why they are auctioning the shop?
Day after tomorrow, 26th.
Why they are auctioning the shop?
They say that the government has issued circular to dispose of the shops belonging to the municipality and it has to be sold in public auction.
Heard learned advocate Mr. So and so for the appellant. The challenge in this writ appeal is directed against order dated 19/9/24 passed by learned single judge. Paragraph. The order reads as under. Quote the pencil braceted portion at page 15. Paragraph. There are two weighty reasons why this writ appeal could not be entertained. Firstly, the order only requires the respondents to file written statement within 2 weeks and further provides by interim relief to the appellant petitioner that the auction proceedings shall be subjected to outcome of the writ petition. Paragraph. The order being interim in nature, the court is not inclined to exercise its appellate jurisdiction. Full stop. At this stage, any of the rights of the parties are not crystallized. Finally, not only that, the learned single judge has, on the contrary, protected the interest of the petitioner appellant by providing that the auction proceedings shall be subject to outcome of the writ petition. Full stop. The court finds that this protection is sufficient at this stage to be availed by the appellant petitioner. At the same time, paragraph, the appellant is not precluded from moving learned single judge for appropriate further interim relief if available in law and on merits. Full stop. Since the auction is stated to be imminent, it is expected that learned single judge will dispose of the writ petition as early as possible. Full stop. Let the writ petition be posted before learned single judge on 30th September to be disposed of in accordance with law and merits expeditiously, subject to the timetable of learned single judge. The appeal is disposed of accordingly.
Please.
Number 4.
The state in the matter, my lords. State is the appellant, my lords.
What is the urgency?
My lords, the urgency is this, my lords, that the respondents were contesting were yet to be served as per the notice of this court. They're
Pardon?
putting up construction on the property, my lords. It's a property which belongs to the government. I've indicated in my AA that the construction is going on. May I just, these copies, my lords may kindly see, my lords, that they're going ahead with some kind of construction. This is a school for the primary boys school, Batrali, my lords. My only request is, let there be a status quo as on today till the disposal of this matter, my lords.
Why?
The construction, even though a ground area which belongs to the school, by virtue of the order passed by the Honorable Single Judge, my lords, they're taking over the entire property and putting up construction.
Have you filed IA?
Yes, my lords, I filed an IA.
Delay is also there.
Yes, my lords.
So notice returnable on.
Notice, my lords, had issued, but since the construction is going on only,
Who appears?
my lords, they have to be served, my lords, as per the cost title. R4 and 5 were the contesting respondents. It's await notice of the service of notice, my lords. The photographs indicate that there's some construction which has been underway, my lords. I'm only requesting, my lords, to
are
protect me
you?
by way of, I'm the state, my lords, where
So your original,
owners, my lord, we were gifted the land, my lords. my lords,
original
with
respond number, number 4,
4 and 5, my lords.
4 and 5.
Yes, my lord.
Your primary boys school.
Yes, my lords, primary boys school, Batrali.
So who is putting up some construction?
Yes, my lords, the petitioners before the learned single.
Where is your IA?
Notes, IA is there, my lords, at page number.
IA number?
Page number 350, my lords.
IA number?
IA 1 of 20.
IA 2 it could be,
Three.
my lords.
3, IA 3. You are government advocate?
Yes, my lords.
Don't like to come to this court.
No, lords,
So
I do come, my lords.
you are additional advocate?
Yes, my lords.
Then you are bound not to come.
Please, my lords.
You consider yourself priceless.
No, my lords.
So don't come to the first court.
No, my lords, not like that.
Only when senior advocates never enter the courtroom. They
No,
stand
lords.
outside and then watch the.
My lords will not take it that way, my lords.
That is we used to do.
No,
when
my
we
lords.
were- Only Advocate General of Mr. Sethi is an exception. He always sits in the court. This is all in lighter way, nothing, there is no significance, nothing. This is all just, yes, what is the, where is, what is the ground?
Page 350 is my application seeking a stay at the hands of this court, my lords. I just produce these copies of the photographs, my lords. That's okay. Now, ಗೊತ್ತಿಲ್ಲ ತಗೊಳ್ತಾರೆ.
The order in IA number 3 of 24. The present writ appeal deferred by the state and its authorities, including the primary boys school, Vattarhalli village, Bengaluru East Taluka, Bengaluru, is directed against judgment and order dated 24th November 23 of learned single judge. In the petition, the respondent petitioners sought to call in question order dated 23/7/21 passed by the land tribunal. the dispute paragraph relates to the land bearing survey number 19 at measuring 6 acres and 17 guntas of Battarhalli village, Bangalore East Taluka. It is the case of the appellant's hearing that the land is earmarked for the purpose of primary school, primary boys' school at the village. For the reasons stated, full stop, F capital, for the reasons stated, learn a single judge dismissed the petition and upheld the order of the tribunal. The challenge paragraph against the said judgment and order is pending consideration on merits in the present appeal. Paragraph. In the meantime, the applicants state and its authorities have filed the present IA in which it is stated inter-alia in the supporting affidavit. Present IA prior to seek the stay of judgment and order of law on a single judge. In the supporting affidavit, it is inter alia stated that the subject matter land is used as a playground for the students who have been studying at the government private boys school, Battarhalli village. It was stated that subsequent to the passing of order by law on a single judge, now under challenge, respond number 5 and respond 6 are bent upon to put up construction, and they are trying to create third-party rights in the land. It was submitted paragraph by learned additional Court General. What is the good name?
Bhanu Prakash Minutes.
On behalf of the appellant applicant, that if the private respondents are permitted to proceed to put up any construction or to generate third-party rights, the challenge to the judgment and order of law on a single judge would become infructuous without it being examined on merits. Paragraph. In the above circumstances, in the facts and circumstances, the submission could be countenanced, when the appeal is yet to be heard and the judgment and order of law on a single judge is to be examined for its merits at the instance of the appellant state, changing status of the land may not be permitted. 4, it may create irreversible situation for the appellant and may infructuate the very challenge. Full stop. In the circumstances, by ad interim it is directed that the respondents, that the parties shall maintain status quo with regard to the subject matter land, which is being used as playground. The appeal shall be listed along with the IA on 6th of November.
Grateful minutes.
Just add one line. The photographs are produced by learned additional Court General, which are suggestive of the fact that the construction material and construction material is brought on the land and the construction is proposed.
Grateful.
Number 5 for the petitioner, my lord. My lord, the urgency is that there are 30,000 residents in Badigi village. On the main road, the gutters have been removed, the drainage has been disconnected, and the residents are suffering from acute airborne, waterborne diseases. If I could take my lords to my application, the photographs that I've produced, on the pretext of acquiring land, the gutters, the drains, the roads, etc., have been uprooted, and the residents have been living with that. In July, they were forced to approach this court with this application. If I could take my lords to my application, my lord. IA 1 of 2024, my lord. All that the residents are asking, let the roads be asphalted, let the drains be covered, let the gutters be closed. If my lords look at page 68 of my application, document number 3, where I've shown the photographs.
Who appears? Who is number 2?
2 is the municipality, my lord. 2 and 4 are to do the necessary works. 4 is
Not-
PWD.
You are not covering the drainage and sewage system. You are for municipality?
I am for the municipality.
So are you not covering the drainage, etc.?
I have done, the main road is destroyed on account of the severe rain, and there is an interim order passed by the High Court.
You filed?
I filed it on the statutory report.
Let him file the reply to the.
My lord, they've already filed their compliance report, and in the compliance report, they say that we need 3 months to comply with this. In the compliance report, this was filed in 2022. Today, we're in 2024.
Sir, file.
There are little children who are contracting dengue there on an everyday basis. All that we are asking, the residents are asking is,
work together in cooperation. So we need a wheel stand, a two-wheel stand, to file the report as to what status and see, ensure that whatever the petitioners comply to.
there are newspaper reports as of July 2024, independent newspaper reports, my lord, which say that the situation of the residents are extremely bad. There is non-existent roads. If I could take my lord to 65.
So which is the present application? One of same, this 150.
1 of 24, my lord. This was filed on 1st August 2024.
Which is your last reply in the petition?
This one, 6-1.
8/6/2023, my lord.
Which is the date? 8?
8th June 2023. We had filed an application seeking appointment of
The
commissioner.
main petition is a public interest petition whereby the petitioners have right to decide the representation. The representation is with regard to providing to the residents of the BYDGI town. Haveri district. The basic civic amenities such as asphalt roads, covered gutters, proper drainage and sewerage system, as well as clean potable water along the Baidagi main road. It appears that the proceedings of the petition witnessed several orders passed by the coordinate bench from time to time. Full stop. The municipal authorities have filed their counter on 8/6/2023. Paragraph. Now in the aforesaid proceedings, the applicants have filed present IA, in which it is stated that the work of drainage and sewage system is yet not completed satisfactory, and in many parts of the area, the drainage is open, which has the potentiality of spreading the disease and ailments. Full stop. It was submitted that the sewerage system is also not properly monitored and not covered, but has remained open. Full stop. There is a long gap from 8/6/23 till date. And the court is not aware of the developments at the end of municipal council in terms of taking steps to provide the amenities and to take care of the aforesaid grievances of the petitioner. In the circumstances, it is directed to dispatch number, which is your number?
R2.
Dispatch R2 municipal authority to file a detailed report about the work of drainage and sewage system. Full stop. The photographs suggest that they are not covered and pass is open on the road. Full stop. The necessary affidavit shall be filed on or before 30th September, put up on 30th September.
Deeply obliged.
Exactly.
Vaishali Hegde.
I had moved this matter yesterday, my lords. This petitioner, my lords, is a cement manufacturing plant company, and also, my lords, has a mining lease in existence from.
This is the same matter where it was kept on 21st/9 and then.
My lords, I had actually made that.
Then what is
My lords, the issue is, my lords, there is a dispute now which has started between the state and the petitioner company. This is a lease which is in existence from 1963, limestone lease, my lords, in Kalburgi district. My lords, from 2004 onwards, my lords, they have started a dispute regarding calculation of the rate of royalty, my lords. We have a cement plant, 2 units are there. 1 unit within the mining lease area, 1 immediately after the mining lease area. It's for captive purpose, we use this limestone, my lords. My lords, the method of calculation of royalty, my lords, was decided by the state government. What they did was they came out with a formula of ratio of limestone consumption. That went to the government. Government said, no, it can't be done. It should be only on tonnage basis. Ultimately, they issued a demand notice on us on the same issue. Lords, we have approached the revisional authority. They calculated the demand of about 900 crores and odd, 700 crores and odd, minutes. We went to the revisional authority. They blocked my ILMS. There is no order of blocking my ILMS or stopping my mining operations till date by the government. My lords, when I go to the revisional authority, Annex A, if your lordship kindly come, my lords, page 56. The revisional authority said within 1 week, sort out this issue. That's the central government. Please come to 56, my lords. Now my plant is shut.
The deemed extension order is passed.
Deemed extension order is already on record, my lords, which your lordships would get at page 78 if your lordship kindly comes.
The short point is,
the relief sought for here before your lordships and the revision petition is pending, my lords. So this parallel proceedings cannot take place, my lord.
What is pending? Revision petition.
Revision,
We have
the
said-
same relief what is sought here is sought in the revisional authority. Bypassing that, my lord, when the matter is pending, this writ petition is filed. Let him, the interim relief and the main relief is challenged before the revisional authority.
May I just complete, my lords? I know, that's what my learned friend permits.
No, I'm sorry, I thought I'm.
Please come to Annex Sharia. That's what I have said so. Please come to Annex Sharia, page 56.
What is this ILMS portal?
ILMS, my lords, it's known as Integrated Lease Management System. I have said so in the
Integrated.
Lease Management System, my lords.
So that permits you to move the.
My lords, what happens is under that, it generates permits to me and I have to pay royalty. That's all integrated, like it's, my lords, only through bank transfer I have to give the money. Now what they have done is they have blocked the ILMS from November 2023. So because of that, as I said, my lord, there were 2 cement units of.
In fact, we are not hearing the main matter.
No, I am only saying, my lords, today what has happened is this. They blocked my ILMS. So I am unable to pay royalty or take permits also. They issued a demand notice for about 800 crores. I went to the revisional authority. Central government has passed an order saying that you try to unblock this ILMS, please come to page 56. Running page 56, my lords. The revisional authority's order.
So that proceedings are going on.
There, my lords, after this, it's not because the revisional authority now is not available, my lords. There is an in-charge officer. Now, what has happened today is,
Revision is not available.
my lords, there is an in-charge officer, is not, and they have not filed their counter. Now, what happened is, during the pendency of the revision, lords, we went, the revisional authority said, approach the state government, give your proposal, state government resolve this issue of unlocking the ILMS, because they have not asked us to stop the mining. Now, my lords, they don't unlock it. My cement plant is stopped. My mining is also virtually stopped because, my lords, I have 3,000 employees on hand. Already 100 employees have given VRS because one cement plant I have now stopped for 1 year now. Then, my lords, IBM now, that is the Indian Bureau of Mines, they have initiated action saying that royalty details are not forthcoming in your returns.
What is the objection to stop this?
In fact, my lord, what we have offered is this to the state government.
What is the reason for stopping this integrated?
They have not given any reason so far. There is no order.
That it might be that your lease period must be over.
My lord, my lease period is deemed extended. If your lordship kindly come to Annexure D, page 78, till 2030, I have a lease period.
Page?
78, my lords, 78. Under, it's a statutory deemed extension, pursuant to which government has passed an order.
His order is passed?
Yes, yes, 78, my lords. It starts at 78, come to 79, my lords. The government order dated 25/8/2022. It starts at 78.
In light of so and so, so and so.
At 79, your lordships would get. In fact, my lords, I voluntarily to sort out this issue, I have sent a DD for 33 crores. They sent it back. Lords, I will only make this submission for an urgent basis.
Where is the order of the? In fact, we'll set down for hearing, but let us understand.
Lords, yes.
If it is possible to
Lords, I'm only saying on an urgent basis, what I am trying to offer is 33 crores is the royalty which I sent a DD to them. Demand draft,
Where is the region authority order?
Annexure A, my lords,
Page,
56, running page 56.
what is the final order?
No, my lords, it's still pending. They have not even filed there. It's an interim order.
Interim order.
It is an interim order by the regional authority. Running page 56, my lords, on 31/7/2024.
You showed that.
Please see para 3 and 4, my lords.
State government is directed to obtain the information required for
Restarting
and resolve problem related to restarting of.
Yes, my lord. Immediately, I go to the Director of Mines and Geology on 3rd August itself.
Anyway, we are not.
Then, my lords,
Yes.
Your Lordship, may kindly see para 3, my lords. During the proceedings, the representatives of the revision raised another issue regarding stoppage of integrated lease management system. The learned counsel for the revision submitted, there have been blocked and downloading email permits from ILMS due to which they are unable to dispatch the minerals. It is also informed by the learned counsel the revision only 15 days for raw material. In response, the state government has submitted has not entered the relevant details of mining, so and so, so and so. What they're seeking to implement is that para 4. Considering the submission, the representative of the revision offered physically to visit the state government's office and provide necessary data and information to restart the ILMS. Accordingly, state government is directed to this is important. Obtain the information required for restarting and resolve the problem relating to restarting the issuance of transmit permit through ILMS. There's no direction as such. Your Lordship, last thing, para 6. In view of the above, the matter
Will not today heard. This is.
may I just make this, my lords, I am not asking for.
Let us see, Mr.
Only one submission, your lordship may kindly consider. Now, my lords, IBM has issued me a notice saying that you are not filing royalty. So my rectification of returns also they have held up. All that I am saying is, I sent a demand draft of royalty to them. I have produced that. They have returned it back.
They only IA is listed, IA number 1 of 24. So you are ready to pay the penalty, royalty.
The royalty I have sent it. They are not, they have sent it back. 33 crores, they have sent it back.
How much?
33 crores. They could have taken that.
Total amount.
That's the royalty from November to up to date, which I have calculated. They can always take it. That also they don't take. They've issued a demand notice now. From 700 crores, they have brought it down to 257 crores, in which principle they say is.
Anyway, we have posted this IA because the matter was.
The problem is, my lords, the cement unit, everything is getting close.
Number 1 of 24, this IA came to be filed with a prayer to prepone the petition. What was stated in the IA was that the petition was petition came to be wrongly posted to 24/10/24, whereas it was ordered to be listed on 24/9/24. Full stop. It appears to be true paragraph that the court had earlier adjourned the proceedings to 24/9/24, but later the appeal was posted earlier than that, and in absence of learned senior counsel of the appellant, it was adjourned to 24/10/24. Since the original date given was 24/9/24, as submitted by the parties, and in view of the subject matter dispute which the court considered to some extent today in course of
subject to correction, notice is yet to be issued.
So this is coming up for the
first time,
time,
notice is yet to be
That's
issued.
all.
I'm sorry, I was just saying, I'll take notice,
that
I'll file my.
can write down. The petition in which the present IA is filed is a fresh petition, which was awaiting to be posted for admission consideration before the court. It appears, paragraph, that the court permitted circulation of the petition to be listed it on 24/9/24 upon memo submitted and as requested on behalf of, as requested by learned advocate for the petitioner. The petition came to be listed prior to the date given by the court. Full stop. On that day, in absence of learned advocate for the petitioner, the matter stood adjourned 21/10/24. It is in this light that the present IA is filed to seek the preponement of the date of the hearing. Since originally the matter was ordered to be posted on 24/9/24, the court deems it fit to list the petition on 30th, Monday.
Please.
Can you make one request?
For admission consideration. Full stop. In course of hearing of the interim application for preponement today, the court, in order to apprise itself, heard submissions of learned senior advocate Mr. Anindra for the petitioner and learned Advocate General Mr. Sashikaran Sethi for the state. Full stop. It appears that while it was submitted by learned Advocate General, that the revisional proceedings are pending before the revisional authority, the order of the revisional authority dated 31/7/24, into page 56 annex A bracket over, reflects that in paragraph 4, some interim direction is given requiring the parties to resolve the problem. Full stop. The court is yet to go into the subject matter dispute. Full stop. The basic dispute appears to be, the immediate dispute appears to be, the dispute appears to be restart of the integrated lease management system.
Issuance of, issuance.
Restart.
Restart. Okay, restart.
Restart of IL.
Restart of.
Restart.
Full stop. Don't write anything about it. Just we'll post it on 30th.
30th, please.
No, nothing on merits.
Please.
You have seen in course of the consideration of the request for preponement, the court considered the submissions of learned senior advocate Mr. Phanindra as well as learned Advocate General for state Mr. Sashikaran Sethi to apprise itself the subject matter. For further let it be posted on 30th.
Great.
If something resolution is
So
possible,
that is what I
go on merits.
suggested to my friend Manoj. There's certain amount due to be paid in submission. Let them sit with the
Well, my
authority.
brother rightly said that the area of dispute is that much only.
So therefore, Manoj, we'll calculate the formula, we issue them a notice, let them go, let them
That's
give.
today also in their formula. That's why I said.
No, let them
30th.
try,
No,
put
no,
it in writing.
I'm not
We may be wrong. We'll put what is the amount, what is our calculation.
Very well.
We'll have it on 30th, Manoj.
Without this, no, 30th, your lords may have.
It is
I will-
possible to conclude or
I will sit with,
here on 30th, yes, otherwise
very well.
Manoj, we are not.
vacation is approaching.
The direct offer, what I had, my lord's instructions was, they have issued a demand notice for 257 crores.
The matter turns out to be short and we'll deal with other.
Please.
We'll hear it in
We'll-
on merits.
My lords, irrespective of this, I will discuss with my learned friend. Before 30th, if we are able to
Told him
come.
if he's paying me, let him discuss with me, otherwise with the authorities. Otherwise with the authorities, let him discuss. Manoj.
Mr. Advocate General, discuss only if you pay.
So let him sit with the mind.
And he is not very generous also.
30th.
Otherwise, we'll hear on merits at
Yes.
appropriate time. Yes.
2:30, if I may.
2:30.
Or let it come in the list, man. Let it be in the list. Let it be there in the list, man.
Because we'll take up in the first.
Whenever the
part,
matter
because
comes on,
Very
please-
last matter will be taking up because
Please,
he's calling the,
Yeah,
only
let it-
urgency and if short matter will be taken.
Please.
Very well. Obliged.
Only urgent matters and short matters on, because 30th will be the almost last.
List number 1, the contempt matter, seal number 1.
Appeal for the petitioner, my lord. Notice may kindly be ordered to the contemner. Notice may kindly be ordered to the contemner because there is a defiance of the undertaking given. My lords will find the order at page 15, my lord. Para 7 of the order of the Honorable Single Judgment. Para 7, internal page number 8, my lord.
Premises to be vacated.
Yes, my lord, and also the rents, my lord. They have not paid the rents also.
Notice
So last-
returnable on 5th of November.
My lord, may I also say request for a hand summons, my lord, so that we can serve.
Pardon?
May I also request for a hand summons? Hand summons.
Hand summons. Notice by hand summons is permitted.
I am grateful.
Service by hand summons is.
I am grateful.
Seal number 2, Mr. Ajmer Mir.
Appearing for the complainant, my lords. The subject matter of this contempt is essentially custody, my lords. The complainant accused are formerly husband and wife. If I may take you to page number 43, my lords. This is the order of the family court regarding the terms of compromise entered to between the complainant and the accused, my lords. If I may take you to clause C in subpara regarding custody, my lords. It says the children shall spend their entire or part of the school vacations with the respondent, my lords. That is the complainant, my lords. Now, if I may take you to page number 50, my lords, wherein I've arranged for all the tickets for all the children to come to the India, my lords, from US. And I've arranged for a caretaker as well, my lords. Now, at this juncture, my lords, arbitrarily, the accused sends an email stating, reneging on the promise that she made that she would send her children back to India for my custody, my lords.
Notice.
My lords, if I may also additionally may request, my lords, I've adduced the email of the accused on page number 89, where we correspond with the accused, my lords. It would be more efficacious if notice may be served via email as well, my lords. At page number 89, I've adduced the correspondence.
Notice returnable on 14th November.
Via email as well, my lords. Via email notice maybe issued by email.
Notice is permitted to be served through the mode of email in addition to normal mode.
Sorry, my lord.
In addition to normal mode, permitted to serve
Grateful.
through the mode of email.
Yes, my lord.
Notice is permitted to be served on the respondents through email in addition to normal mode of service.
Seal number 3, Mr. AJ Srinivasan.
Notice returnable on 11th
My lord,
November.
a similar matter in the same is on 24/10, my lord. Your lordship has issued notice.
24/10.
24/10.
24/10.
Same professors in a different college.
24/10.
Seal number 4, Mr. James.
This is a interim custody matter, my lord. The father has not obeyed the order. Impugned order is on page 99. Through consent, my lord, both the parties had agreed for some visitation arrangements, my lord. Only once he has complied, my lord, and thereafter he has not been complying the orders. 2 notices have been sent, my lord, that has not been done. Subsequent to this, my lord, the trial court
So
has,
It is a boy.
boy, my lord. He's an autistic child.
What is the age?
He's 15 years.
15 years.
He's an autistic child. He's an autistic child, man. So his mental age is about 6-7 years.
And staying with mother.
He is now, the custody has been transferred to the mother. Man. But this is during the period when the custody was with the father and he had disobeyed the orders.
So at what interval is to be taken for treatment?
Sorry, my lord.
At what intervals the boy is to be taken?
He
for
is
treatment?
regularly on treatment, my lord. There is a treatment procedure itself for him that the mother is taking.
So then what is the contempt?
Contempt is only for the visitation rights which were granted, my lord, by the family code.
Page
In
99.
page number 99, my lord, kindly see the 5th paragraph, my lord. With the consensus of both the parties, the visitation rights passed on 3/11/23 shall continue until further orders. That is the impugned order.
Where is 311/23?
311 is on page 96, my lord. It shows, my lord, the order by the 6th line, my lord. The order passed by this court earlier has to be carried on for 2 months. Depending on situation, the necessary order will be passed. Visitation during weekends in rotation. So there are 2 children, my lord. There are 2 children. The daughter is with the mother. Son was with the father. So one weekend they are supposed to do it. So mother diligently follows the orders and sends the girl child, but the boy child was not sent.
Notice reopening, 21st October.
Obliged.
Number 5, Azhar Mir. Appearing for the complainant in this matter, my lords. The complainant accused in this matter are essentially landlord and tenant. I initiated eviction proceedings before the London Commercial Court, my lords. I secured an interim order in my favor where the accused was directed to pay the admitted rent of rupees 4 lakhs since the date of institution of suit, my lords. After the passage of order, my lords, I have not received a single rupee from this accused, my lords. At page number 18, my lords, I've adduced the interim order dated 15/4/2024, my lords.
You can go before the court where it is pending.
My lords, I've already filed an execution petition, my lords, that is pending, my lords.
Go there. Why?
But my lords, the arrest notice has been issued against him, my lords, but he's reneging on his promise, my lords. He's reneging on his promise. Additionally, he had taken an undertaking before the Learned Commercial Court stating that he would hand over the keys, my lords. And that is also certainly in contempt at this point, my lords, and is not abided by it, my lords.
Not?
He's not abided by his own undertaking before the commercial court, my lords, the accused. Therefore, my lords, a notice may be issued.
So 39(2)A will be applicable. Order 39(2)A. You can find application of that.
My lords, but it's a substantial order, my lords. At this point, this order is almost worth 70 lakhs to me and is certainly just been had not to have possession of this the tenant property, or am I getting any rent at this property, my lords? The accused has preferred a writ petition against the order as well, my lords, and there was no interim relief granted to him as well, my lords.
What is the date of this order, page 13?
The date of this order was 15/4/2024, my lords.
You go there only. The jurisdiction of this court under the Contempt of Courts Act 1971 is sought to be invoked by the petitioner and as complainant in respect of order dated 15/4/24 passed by learned Additional City Civil and Sessions Judge, Commercial Court, Bangalore. Directing inter-alia, directing the defendant inter-alia to deposit the admitted rate of rent of 4 lakhs per month from the date of suit till the date of disposal of suit, along with the other incidental directions. Full stop. The order came to be passed upon application under section 151 of the Code of Civil Procedure, whereby the direction was sought against the defendant to deposit the arrears of rent to the tune of 31 lakhs. Full stop. since it is possible, since it would be possible and permissible for the complainant petitioner to work to resort to the remedy about the grievance raised in this petition before the very court where the suit proceedings are pending, and to work out the rights and remedies. This court is not inclined to invoke the contempt jurisdiction. First of the present paragraph, contempt petition is not entertained on the aforesaid ground alone, relegating the petitioner to avail the remedies before the same court, avail the appropriate remedy before the same court by filing appropriate proceedings, appropriate application of the proceedings to work out his rights and remedies. This court has not gone into the merits of the case.
My lords, if efficacious remedy is not available in either execution, would I have liberty to file afresh, my lords? If I would have liberty to file afresh.
Even if any application is required to be filed by the petitioner afresh, it will be permissible for him to be done in accordance with law.
Number 6, Mr. Dharmapal.
This case, the complaint, my lord, husband files a divorce petition against the wife, and the divorce petition was allowed. Against the decree of divorce, the wife complainant has prepared a MFA before on report and granted an order of interim stay.
So what is
That
this?
is
What is this interim?
page number 10, my lord.
Page number?
In spite of that, he got married second time.
Page number?
Page number 10, my lord.
10.
Ink page number 10.
So this is the only order.
That is Annex A.
Issue
That
notice
is
to respondent.
issue notice to the respondent, KL Srinivasan and council accepts the notice for the respondent. Interim stay of the impugned judgment and decree. So in spite of that, wearing that order, he has performed the second marriage.
What is the decree?
Second marriage. Now there are few days of delay in filing this complaint, my lord, so by collecting the evidence and all.
You go before the same court and work out.
Notice.
Why should we issue notice?
Now she has filed a PCR against him that someone's issued.
Notice returnable on 28th of October.
Number 7, Mr. H.M. Muralidhar.
I'm for the complainant, my lords. Here the accused is a joint cooperative society, my lords, where complainant used to work. So in the year 1993, they had refused him from the work. So he had filed a dispute before the joint register, and the register had passed an order in 2007 to dismiss the dispute raised by the complainant, my lords. So the complainant raised an appeal before the KAT in the year 2008, my lords. The KAT allowed the appeal order dated 26/9/2014 and reinstated him as a regular and permanent employee, my lords. So the accused cooperative society had filed a writ petition against the order passed by the KAT, my lords. So in the during the pendency of the writ petition number 35377 of 2015, both the accused and complainant came to a settlement, my lords. So here, as per the settlement, the accused was taken up as the employer's regular employee from 18/8/2015, my lords. So since then till 28/2/22, he was working as an employee, my lords. They have not paid him the scale of pay properly, my lords.
5th of November. 5th of November, yes.
Number 8, Mr. Subramanya Bhatt.
Notice written on 7th of November.
Number 9,
Notice.
Please.
Number 10.
in both
1st
my,
November.
I'm great.
Number 10.
9, that is 9.
9 same.
You are in 9?
No, it's 10th.
Both same.
Number 10.
Lord.
Notice it on 6th of November.
So number 11.
Notice it on 7th of November.
So number 12, Mr. Anis Juice.
Notice it on 12th, 7th of November.
That next matter also same.
What is this finance, what is your direction? Let us see. That is, I am not able to understand. Though some compliance is necessary, but what is the compliance? Petition
My lord, it's operating.
to same relief as granted to so and so finance company limited.
In this matter,
So, what is that remit?
under the operative
Writ
portion is.
petition is disposed of by directing the police to restore the seized article. Same,
Yes, sir.
same.
Same minutes. My
What
lord,
is the direction you are seeking to comply with?
my lord, the operative portion is page number 17, para 4 minutes.
Page number 13.
Page number 17, paragraph number 4.
No, we are on 888 of 24.
888. Same minutes.
With the direction.
My lord, sir, page number 17, paragraph number 4 minutes.
In this matter, your lordship, there is no contempt, if I may take a minute, your lordship.
You have to endure the articles. Like.
No, my lord, what has happened is, he is the receiver of stolen property. The modus operandi is this in this matter, your lordship. An offense is committed.
To take instance.
Yes, I already filed a compliance affidavit in this matter, your lordship.
No, my lord, not to.
My lord, I think we have prepared the affidavit, the instruction. I will just update. My lord, what has happened is the order, it is mentioned regarding that covered by the other judgment, your lordship, where it says, without following due procedure of law, that the officer is required not to recover the material that is in the here.
File your reply.
Yes, my lord. We also.
Reply.
Yes, my lord.
Therefore, at least I was not clear, therefore, yes, what is the direction?
No, my lord.
File your reply.
But the relief lies for them is to go before the magistrate and not before this court, because it's a matter
On merits.
We'll consider on
Yes,
that.
13, same.
Same minutes.
Same.
13 also same minutes.
So number 14.
Notice notice minutes. 8 minutes.
14. SK at
Notice,
Please,
notice
notice in
written
this
on
matter.
5th of November.
Please, oblige.
Number 15.
My lord, this is the matter. Lord,
SCST PTCL, limitation.
Oh, that.
Act 11 of 2023, my lord, it is heard. My lord, it was heard on Saturday. My lord, it is adjourned for a reply. So if my lord could have it after, my lord, 2 weeks, then we'll be able to know.
But the Harvard bench has taken some view.
It has taken a view, but now, my lord, we are waiting the order of the learned single judge, since it is more or less 90% through with the arguments. Otherwise, my lord can even hear this matter, because that, my lord, in all these matters, Act 11 of 2023 is not challenged. But what is challenged is the order of the Deputy Commissioner.
May I make a question?
Except for 2-3 matters where the act is challenged, all the others, my lord, it's the order of the appellate authority that is before my lords.
Division bench of this honorable court, my lord.
No time now, after vacation.
Already taken a view that, my lord.
23rd of October. 23rd October. In the meantime, some development may take this. We will learn.
Obliged. Interim order may be extended wherever, interim order.
All interim orders will be extended. Wherever it is there, extend. There can be a common order in 15 to 15.43, 44, 45. Send over to 23rd of October, 2024.
44.
The interim order shall stand extended wherever they are operated, wherever it is operated.
Serial number 44. Just now,
40.
44.
Yes. PL matters, SC number 16. Mr. Murali Krishna Brahmanandam,
Appearing for the
14
government
person.
man. This is the matter where he wants to be temporarily elected as a mayor for BBMP.
He is not here. Where is he? He must be staying in Mayor's bungalow.
Please.
That party in person is not present. Therefore, in the larger interest of justice, hand over.
Whether it complies with the 2018
This petition is of the year 2022. The orders passed earlier indicate that the party in person is habituated to not remain present. Full stop. On last occasion, order was passed on 12/9/24. But today also the party in person is not present. Giving one more chance before the petition could be dealt with in accordance with law. Must hand over to be dealt with in accordance with law and as per earlier order dated 12/9/24. Must hand over to
the early
22nd
order of the,
22nd October.
it's mentioned in the petition, my lord, which was withdrawn.
Number 17, Shumapati, yes.
For the petition, Madam.
What is it about?
Madam?
What is it about?
Madam, we want to implement the direction of the government notification and also the CCS conduct rules, wherein the government servants should not bring political pressure in transfer of their this one, Madam. In spite of these notification, all the transfers are being made at the behest of the MP, MLAs and MLCs. And as a result of which, purity and efficiency in the public administration is deteriorating.
They are doing what?
No, my lord,
Yes,
this is.
Madam, all the transfers that we have produced is at the behest of the MLCs and MPs. They cannot bring the political pressure, my lord. They cannot bring the political pressure. Even the CCS conduct rule says that. Even their own notification says that if you bring the political interference, then action will be taken against the concerned public servant. In spite of this, MP, MLAs and ministers are issuing the transfer order, that too beyond the transfer period, madam.
This is your prayer. Is you approve it in the nature of mandamus?
Yes, my lord.
Order direction to place the recommendation of the committee constituted by Annexer G before the report. What is that committee? What is that representation? What you are arguing? What is this matter?
This is about the transfer policy, my lord.
Look at your diary. You look at your electronic diary and find out which matter.
Sorry, my lord. So there are two petitions by the same petitioner. File is missed. I am very extremely sorry, my lord. I am extremely
When shall-
sorry, my lord.
So which matter we adjourning? The matter you are-
Madam, that is the,
Now tell us which matter we should adjourn. The one which you are arguing or one which we have?
any date may be given, my lord.
Which, no, which matter to be adjourned?
This is a transfer policy, my lord.
That is not with us.
Yes, so the file is not on the record.
So we can adjourn, we can dismiss this and adjourn.
No,
that.
please, my lord. This is my mistake. It is my mistake, my lord. We misplaced the file, my lord.
Our dilemma is that which is to be adjourned now, this or that?
What is listed today, madam, maybe urgent, madam.
Maybe
What is listed today, madam? Sorry, madam. I'm very sorry.
25th of October, 25th of October, at the request of learned counsel. Petition.
Much obliged.
Seal number 18, Mr. J.R. Mohan.
There for petitioners in this case, my lord.
बहुत किया है इन्होंने।
My lord. In this writ petition, I have sought for a direction to the respondents to consider my recommendation. My prayer in this writ petition is very limited, my lord. If my recommendation is considered, it is more than enough for me. The matter is regarding for a direction to the respondents to consider my recommendation for construction of a freedom fighters monument in memory of the freedom fighters who have fought for this country.
The prayer in this public interest petition is you go before them, is to direct the respondents to construct monuments of the freedom fighters and martyrs who have sacrificed their lives for the freedom of Hyderabad, Karnataka region. It is further prayed to set up a committee for writing and publishing their history and biographies by considering the representation made by the petitioner. Full stop. Learned advocate for the petitioner, Mr. So-and-so would submit that the petitioner has no personal interest in this subject matter. He submitted that at the time when the country got independence on 15th August 1947, the Hyderabad Karnataka region was not free from administrative control of the Nizams of Hyderabad. It is submitted that with active participation of the various freedom fighters, the then Home Minister, the Sardar Vallabhbhai Patel, got freedom for the region, freed the said region from the clutches of the foreigners. It is stated that various freedom fighters from the region have sacrificed their lives for the cause of motherland. Some of them are still alive, whereas some of them have passed away. It is the say of the petitioner that those freedom fighters who have sacrificed their lives and property for the freedom of Karnataka, Hyderabad Karnataka region should be properly remembered and their memories should be preserved. It is submitted that in this regard, monuments, their monuments should be erected. And there should also be publication of their history, biographies, works and deeds. Full stop. There is no gainsaying paragraph. There is no gainsaying that remembering and respecting the freedom fighters and martyrs who fought for the country and motherland is the solemn duty of entire nation. And for that purpose, all the state governments have to be committed to the said duty, such duty. The prayer of the petitioner, however, prayer of the petitioner for construction of monuments of the freedom fighters of Hyderabad, Karnataka region and to publish their history and biographies may be justified. However, it is not the court, it is not for the court to entertain a public interest petition on that score. The action in respect of subject matter lies in the domain of the state government. In the circumstances, expecting appropriate response from the state authorities to the grievance of the petition, to the cause espoused by the petitioner, it is expected that the memories of the sacrifices of the freedom fighters and the martyrs of the region would be properly promoted, properly nurtured, safeguarded and promoted by all appropriate means by the state authorities. The representation of the petitioners will be considered by the authorities with positive approach. Full stop. With above limited observations.
My lord, may I make one submission? My lord, the annexure A representation, my lord, it is given to respondent number 2. My lord, they have their own panel advocates, my lord. So direction should be issued to the respondent number 2 to consider the representation. Since the representation has by annexure A.
It will be open for the petitioner to file a press representation in addition to one already filed, which shall be considered by respondent number 2, the Secretary Karnataka, Kalyan Karnataka Regional Development Board.
Obliged.
The petition is disposed of and not entertained, subject to above limited, is not entertained and disposed of, subject to above limited observations.
Number 19.
This petition is with regard to a direction to the respondents to construct a Pakka road between Someshwara Temple and Chakrakoti Bhayava Mat.
I'll find out
To
what.
consider representation, that's
This is also to
yes, madam.
consider the
Yes, madam.
representation.
So representation disposed of. So within 3 months you may decide. Yes, next.
Number 20.
Appear for petitions.
Similar one, my lord.
This is, my lord, with regard to construction of a sports stadium for the youth of the locality. There is no sports stadium, Your Honor, my lord.
Same.
Yes, ma'am.
All. But how many representations we would make? You will to draft, you will have to draft all for all your clients,
Yeah, yes, ma'am.
isn't it?
Yes, ma'am.
Next,
Much obliged.
same 3 months, within 3 months.
Number 21, Shri Vishwanath Sabrad.
My lord, this may not survive for consideration. For the simple reason, my lord, they are seeking for suspension of New Year celebrations for in December 2023, which my lord gets it at paragraphs
Vishwanath Sabrad.
my lord, sorry, my lord, 1 minute. My lord, paragraph 14, paragraph 9, 11, 14 and 16. It all says for New Year celebrations, my lord, on the night of 31/12/2023.
Not to allow infectious.
Infractions 31/12/2020.
Who appears? Here, Vishwanath Sabarad. Prima facie, in view of the prayers for the petition, would not survive. However, since learned advocate for the petitioner is not present, to be listed on 27th of September at 2:30.
Obliged.
22, urgent. Number 23, it's green bench matter.
I appear for the
Sui-
petitioner's counsel. The petitioner has 3 quarry licenses and also crushing license, my lord, which are all current, valid up to 2030, 35, etc. A so-called Bharatiya Prajasena or some organization makes a complaint at page 157, annexure E.
Reply is filed.
But they have not filed anything. And under annexure E, page 157. Say to the petition committee of legislative council. It appears legislative council, the ex parte sends it to the government to get a report. Department of Mines files a report which says all the required licenses, etc., are all obtained. There is nothing wrong with this. Again, the committee sends the petition committee, asks for another report. There also there is nothing wrong is found out against us. After all these reports, now under annexure L, a communication is sent to me by the director of mines stating that petition committee has resolved to stop your work. The lordships would get it at
This is
page
coming
39.
Coming for the first time?
Yes, my lord.
Coming for the first time.
Notice written.
They have stopped my query by this petition committee for the last 1.5 months. Petition committee nowhere comes into picture. Legislative Council Committee, nowhere it comes into picture.
Find out.
Yes, my lord.
The 1st of October.
least as regards that.
Notice and notices to interim relief, returnable on 21st.
Number 24, Mr. Anirudh R. Nayak.
In this petition, we are seeking for a deemed consent for operation. This is the fourth time I'm coming before my lords because on previous occasions, my lords had directed the authorities to decide the matter within an outer limit of 6 weeks, despite which they have still now kept the matter pending. My lord's earlier order, my lords will find in annexure V, page number 127. Relevant page at page number 130, my lords. Para number 6, page number 130. So now, despite this, my lords, at annexure B1, the respondent authorities, annexure B1, my lords will find at page number 147.
So therefore, this petition is filed.
Therefore, this petition is filed seeking for a deemed consent for operation in terms of section 25, subclause 7.
My lords, may look at page 25, my lords, which is the prayer column. Opening statement cannot be made to look like we are in contempt by the petitioner. My lords may turn to page 25. He's seeking for a quashment. My lords, on page 25 of annexure B1, which my lords would find at page 147. A letter which I have written to another authority. He's seeking for that quashing of that order.
Marking a copy of that to me. Because they, despite the existence of the High Court's order, say that they are going to keep the matter in abeyance.
We never said so.
That is what is said in the letter.
What? Then in that case, my lords, this may not be the right.
My lords,
petition
may
date.
see. No, how many
advise
times,
them
my
on-
lord? It's been more than 1 year. It's been more than 1 year that they're dragging their feet. Last time to even adjudicate this matter, I had to file a writ petition. 6 months they dragged.
When we had already.
I file a writ
adjudicated.
petition, then they decide. My lords then passes an order saying within outer limit of 6 weeks you decide. Now they write a direction to me saying, no, we are going to keep the matter in abeyance.
No, we never
Should,
said them.
that is what is said in the letter, my lords. Kindly see, my lords.
Please, my lords.
Page number 147. The second para on page number 147, if my lords would take. The third line there from your department being, my lords have that? Your department being the nodal agency with respect to matters connected to sugarcane crushing, your observation refrains this board from taking further decision on issue of consent. My lords, with all due respect to this authority, my lords had directed them to decide within an outer limit of 6 weeks. Though they cite it in the letter, I mean, they are not taking cognizance. They say, I'm going to keep the matter in abeyance. Let them decide, my lords. Now, if they don't decide, am I supposed to wait, my lords? Section 25(7), I would just request my lords to take section 25, subclause 7 of the Water Prevention and Control Act. 25, subclause 7.
What is the urgency?
Urgency is for the past 1 year, I have been shut. They have not been permitted me to operate.
Yes, my lords may turn to page 25. I'm again requesting my lords. What is seeking for is quashment of annexure B1.
And grant of deemed
And-
CFO.
And
And grant of CFO.
My lords, sir, please.
Sure.
And grant of deemed consent. And my lords, subsequently, the prayers, if my lords may see at page 28, ask us not to take any action whatsoever.
On sugarcane control matters,
My lords,
what
not-
they're doing, my lords, is
That's
they,
Let him to argue.
sure, sorry,
Permit-
I'm sorry.
Permit us to understand at least, yes.
My lords, a similar writ petition was filed, my lords, a year ago, whereby, my lords, the direction was sought by the petitioner, the same petitioner. My lords, I just give the writ petition number, my lords. I the copy was served, my lords, I'm yet to file my objection. My lords, where the direction was sought saying that no action should be taken against the industry at all. My lords, it was dismissed by saying that such innocuous prayers can never be made
It was-
unless action is initiated against you. My lords, now, my lords, they repeat the same episode. My lords, that is one episode, one aspect of it. The second aspect, my lords, for us to consider, the CFO, my lords, had directed within 6 weeks, we have to consider the entire action. My lords, we are in that process. We are in the process of considering it. In that, my lords, we receive a communication from an authority, which I would place it on record.
It's there already.
I would place it on record. There's no urgency in the matter as such as which is being claimed. Now they themselves are saying that we are not operating.
Because of the authorities not taking any action and direction. My lords,
That it's a complete misnomer
My
or
lords,
an
he's-
argument which is made in vacuum, my lords. Initially, an opening statement was made that a writ petition has been filed seeking a deemed consent. Now, my lords, when I pointed out to this annexure which is impugned herein, they say that, my lords, it's a contempt of this court.
I didn't say that. I'm very sorry, I didn't say
My
that.
lords, it's.
I didn't use the word contempt at all.
It is, my lords, saying that, but at the same time in an indirect manner. My lords, I would only request one thing. The copy has been served. Notice may be issued. Notice has not been issued. My lords may have it next week, either on 30th of or on.
Can I, may I, my
30th,
lords,
my
with
lords,
my
I
lord's
would,
permission, may I kindly take my lords to annexure Q onwards?
Yeah.
Or even before that, my lords,
He's
annexure,
placed all the judgment.
annexure M, can I, please? Annexure M onwards, my lords, page number 99. That is my application. And that application came to be filed after a writ petition was filed and a direction was issued by this honorable court. Annexure M, page number 99. That was dated 3/12/2023. Now, my lords, page number 104, if my lords see, which is annexure N, consent for establishment came to be issued by them. They issued me that consent. My lords may thereafter see page number 113, suo moto they withdraw that consent which was given to me. That again, I challenge that. My lords may kindly see annexure P. Now, what they did is they said, I will consider your representation, therefore I withdrew, and therefore the order was passed by this honorable court saying, we dispose of this writ petition. Thereafter, they again pass an order saying, cancelling the petition, cancelling the request. A fresh show cause notice is thereafter issued, my lords. Page number 120, annexure S. Now, if my lords see in that annexure S, the only allegation that they make against me, and I have to rebut, is that there is a piping arrangement that I have made, Brahmanand Sagar Jagri and Askins. Now, that piping arrangement has been removed altogether. So that addresses that issue. Now, my lords, on a completely different ground, not made out in the show cause also, they seek to withdraw. They say they seek to keep it in abeyance.
Replies will be filed. Notice returnable on 3rd October, replies will be filed by.
My,
This was at my behest. I tried to complain with all the acts to communicate. Because all earlier of the litigation members have been a party.
no. This is not right. He had filed an impleading application. It was not accepted. I can take my lords to the order. My lords, this Honorable High Court's order is right here. It's enclosed to the petition.
That's on 3rd October.
On that day will come.
My lords, next week, my lords, because it's been more than 1 year that I'm not functioning, my lords. There are so many employees who are not working.
2nd October.
That's it's a holiday.
He wants next.
No, my lords, that may be decided next time, my lords, because his impleading application, even on earlier occasions, has not been accepted.
October is a holiday.
My lords have passed an order in a similar petition where deemed consent has been granted.
Let them file reply.
My lord, next week, my lords, may.
Next week we will keep. 2nd October. Or 1st October.
I request not on 1st October. I have a matter before.
You also on 2nd October.
3rd October, my lords. 3rd October.
When you will file? He has some urgency. He has some urgency. When you will file reply? All of you have to file reply. Today, what relief can be granted to you?
My lord, subject to the outcome of this writ petition, permit me to operate. Because even my Jaggery unit, they are not permitting to operate.
30th October, my
That
lords.
will amount.
Sorry, 30th September. Monday, my lords. If that's convenient. Otherwise, my lords, after vacation, we have no urgency.
After,
Not after vacation, my lords. I'll be dead, my lords, by then.
not after.
My lords, please, I request, I implore my lords, 30th,
30th.
Grateful.
grateful.
Writ appeal matters, so number 25. Saurabh RK.
What is it about? This can wait.
There's it's a 100-bed cancer hospital, there's an interim order passed in this matter.
Interim order is passed.
Status quo, it is half constructed, Person,
No,
Your
no,
Lordship,
it's-
can you see the photographs?
Let's-
Understand, Your Lordship, is
What is the interim order?
status quo. It's on in fact, we have given an assurance that we will not put up further
Undertaking given by the
Yes.
additional advocate.
addition. And
Lords,
it's,
it may be taken up immediately after the vacation,
My
the
lords,
first week following the
my lords,
vacation, my lords.
can you allow,
I just wanted to, my lords,
we'll go ahead with the construction, subject to the outcome.
Lords, my land
And
is lost.
Just
Lords,
one
I don't want to
submission.
lose my land, my
One
lords. This is a
submission.
private property. Lords, I have a decree in my favor. There is an adjudication which has already taken place. My lords, may I just,
EIL, no.
no,
No,
my lords, it's a private property, my lords,
It's a
which the
appeal.
government wanted to give it. My lords, may I just make this request, my lords? I just, my lords, the deputy commissioner has given an inquiry, has initiated an inquiry to find out whether this property, because deputy commissioner is a competent authority under the Municipalities Act, he's given, my lords, a hearing date on Thursday, this Thursday. He's asked us to bring the documents to show how we are concerned with this property. And so also, my lords, the government has directed, the deputy commissioner has directed the municipality to bring the records to show how the property belongs to the municipality or otherwise the government. Notes, this is a hearing which is now fixed on Thursday. Even if your lordships were to have this matter on 30th, my lords, I will come back to your lordships with the outcome of the proceedings before the deputy commissioner.
We have already invested 50 crores on the hospital, my lords.
I did in the first day of review,
Please, my lords.
14th.
Well, if only may I persuade you. Let us put, we won't claim equities, my lords.
Lords, the land will be lost. I can't ask the government to pull down the structures in the event I win the.
It's not,
situation,
not
government
lost,
said
it
that
is
will
not
be
their
lost.
land. Construction has come up already.
No, no, there is no construction.
15th we are-
Your Lordship, may kindly see the photo.
This is the photograph.
Your Lordship, put.
Let it be on the reopening day, my lords, because it's.
May
Please,
kindly see the
great.
photo. Your Lordship, may kindly, just for a moment, kindly see the photographs. It's not that construction is not. It is stopped, no, construction has been,
Basement is complete. Columns have come up.
because this will get depleted.
No, no, we'll take up on 14th.
Please, my lords.
Leave it. I'm,
14th at 2:30.
Lordships.
please, man. For report.
Sorry, my lords.
Thank you. Yes.
15th, that's good. My lords, 14th, I'll be traveling back to
Yes.
Bangalore on that day morning, my lords.
And even better.
My
even better.
sincere apologies, my lords. My apologies to, can it keep one day later, my lords, 15th to 2:30.
15th.
Please. Grateful, my lords.
We don't want a tired lawyer to argue, my lord. We want a invigorated lawyer to argue. We want an invigorated lawyer to argue, not a tired lawyer.
Grateful.
It
my
comes,
lords.
my lord. We prefer him tired, no? He's got so much of energy. Sometimes.
No, I'm breaking it.
He'll argue better when he's tired. No?
Grateful, my lords.
Case number 26, to Karthikeyan BS.
I prefer respondent number 3 in this case, madam.
In pleading applicant, my lord.
For the appellant, my lords.
That undertaking, my lords, requires to be extended. It's in the previous matter.
Stand out, stand out to 15th of October as requested. The undertaking given earlier, recorded the order shall continue to operate.
Grateful.
So this can also go to no urgency. 26 will go
Please,
to some other dates after 24th, after 29,
please, my lords.
29,
29.
delay of 323 days. Notice.
27, 28
There are
urgent.
some pending applications, my lords, at least if those applications are disposed of.
It could be allowed, my lords. I am.
Which one? Which one?
26. In 26, my lords, I have filed an application for impleading.
Impleading.
Pleading and production of additional
That can be
documents.
granted.
Let them be permitted to come on record. I was the writ petition, my lords, let them come on record.
So
Again, on
impleading
this ground.
application is granted.
My application is on 31st May 2020.
IA 5, 6.
7.
IA 5 and 6,
5 and
IS
6 are granted.
IA 7 may be taken up along with the main.
And IA 7 of 24 to be heard with main petition.
Lords,
Yes,
great.
much.
Grateful.
Main appeal.
7,
To be
28
heard
are
with main
urgent.
appeal.
Number 29, sir. State appeal.
My lord, I appear for the appellant. My lord, there is a delay of 323 days in filing the appeal.
My lord, I appear for complaint in contempt petition, my lord.
So will condone the delay or not? What do you propose? Where is the data?
My lord, my submission is, my lord, they have failed to comply the orders of this Honorable High Court. So after nearly 1 year, they have come with writ appeal without complying the Honorable High Court orders.
So you are representing all parties, all respondents?
Yes, I am for a petitioner, my lord, complaining.
My lord, there's a single respondent.
I am for the complaint in the contempt petition.
It is your appeal.
My appeal,
So he is the only respondent?
yes.
Complainant for the complainant in the contempt petition.
In this appeal, he is the only respondent.
Your complainant in complaint petition, and respondent in appeal.
Yes.
Clear? Clear. So shall we condone the delay now?
My lord, this writ appeal cannot be maintained at all. Because,
How can we decide without condoning delay?
my lord, my submission is, see, they have not complied the Honorable High Court orders. You, nearly after 1 year, they have filed writ appeal without complying the.
Generally, we condone the delay. Unless you argue so vehement that you are not arguing.
Sorry, my lord.
Very mildly arguing, don't condone. So we condone the delay.
In fact, they have not filed even reply for my complaint, so what called contempt.
That we'll consider when we deal with the appeal. So 323 days is delay, condonation of 323 days delay is paid for by the state, which has occurred in filing the writ appeal. The delay, the passage of time leading to delay paragraph is explained in the supporting affidavit. The passage of time is largely attributable to administrative reasons. It is stated that the file is moved from one department to another in its hierarchy before the final decision could be taken to prefer the appeal paragraph. Since the appellant is state, decision making process at its end necessarily takes some time. Viewed from this angle and given the reasons which are administrative in nature. And further applying the principle that the delay should be leniently viewed once some plausible explanation is offered, from a sufficient cause is made out to condone the delay of, what is the delay?
Yeah, my lord, 323 days.
323 days. At the same time, while condoning the delay, from a length of the delay could not be overlooked. Full stop. Delay of 323 days is good enough to impose a token cost of rupees
My lord.
1,000 on the estate.
My lord, I not even received.
Delay is condoned.
Still copy also.
My lord, payable to?
So notice in the beginning, notice to the respondents, learners, government advocate, Srimati Nilofer Akbar accepts notice, then entire order. You will accept the notice.
Except, but I not received copy, my lord, sir.
My lord, I'll furnish.
Accept the notice. Notice returnal forthwith. Learned advocate, so and so accepts the notice. Then say heard learned additional government advocate, Srimati Nilofer Akbar for the applicant state and learned advocate for the respondent. Then entire order. Accordingly, delay is condoned with cost of rupees 1,000. To be paid to
Legal authority. Legal authority.
legal authority, Karnataka High Court, state legal authority.
Oblige me. Date.
So appeal may be listed on when? On 23rd of October.
October. Oblige me.
So number 30. Mr. Shrikant MP.
Serial number.
Appearing for the petitioner, my lord. Kindly have short accommodation.
Pardon?
Kindly have short accommodation.
Short accommodation, all right. 7th November. As prayed for.
Number 31, state appeal.
Lord, I appear for the appellant in this matter. My lord, there is a delay of 263 days in filing the appeal.
My lords, this is a matter when there is an illegal demolition of 2 acre 28 guntas of land, my lords, which the petitioners are all site holders who have purchased, my lords, way back in the year 2007-8. Their vendors, my lords, purchased in the year 1997-98. It is now the contention, my lords, of the government that these are all government lands. The only
We are on delay. Shall we condone the delay?
My lords, I would just request for an early hearing, my lords. From 1 year, they have not handed over possession back to us.
So, madam, one more installment of 1,000 rupees.
My lord,
What is-
it's below, it's just 263 days, my lord.
My lords, when there is illegal demolition, the Tahsildar must be directed to pay at least 10,000 rupees cost, my lords, to our advocates welfare fund, not to us.
What is the delay?
263 days, my lord.
260. Normally 250, exceeds 250,000. That's a formula I was used to adopt in Gujarat. So 1,000. Same one. Notice accepted by learned advocate Ms.
BB Vidyulatam.
Dulat. Same.
My lords, a shorter
So,
date, my lords.
Appeal may be listed on 29th October.
Great.
Obliged,
Not 29th, my lords, 29, 30, 31, I'm not there. November.
5th November.
Obliged.
Review petition. Seal number 32, Mr. MS Devraj.
Civil suits are pending. Only what I wanted was, my lord,
I will give
your
you-
lordships had, my lord, and it was dismissed at the time of preliminary hearing itself. My lords had suggested, my lord, that one observation will be made that the civil court will decide the matter irrespective, my lord, without being influenced by the observations of the learned single judge or this honorable court. That has not come.
Yeah.
That's why, in fact, the order of the learned single judge, my lord, passed by Justice Arvind Kumar is that, my lord, they must register the same thing.
This can be done. Madam, who appears?
Nobody, my lord. It
The
came up
notice-
before at this.
Notice,
My lord, the-
notice written on 15th of, not 15th, 16th of October. To be listed at 2:30. Service by end delivery
Please, my lord. Yes, my lord.
permitted, so that you can dispose.
Yes, yes. It,
Complaints in contempt matters, number 33. Srinivas V.
My lords, I appear for the accused. Just to come on record, I filed my NOC wakalat in this matter. There is apparently an affidavit which is filed by the earlier lawyer. I may be allowed to look into it and make submissions. my lords.
Time,
Yes,
when, after,
anytime.
28th of October,
Grateful.
at the request of learned advocate, so and so, for BBMP.
Number 34.
Lord, I'm appearing for the
P. N. Nanja Reddy.
case indeed. Lord,
Yes,
a
for the
writ appeal
complaint.
has been preferred against the order passed by learned single judge. Lord, it may kindly be listed along with writ appeal number
Be listed with writ appeal number
1264 of 2023.
1264 of 2020.
3.
3. So 2003 is coming before this one.
23.
23.
23.
No, not before this.
No, writ appeal of 24 on.
That retirement benefits.
So stated that the writ appeal is filed. The present contempt proceeding may be posted next on 5th of September. Before that, you obtain the necessary order,
Move the
either
matter, please.
Number 35. Mr. G.S. Venkata Subra.
complaint.
Use. Order the matter of status quo in an MFA. Only submit 39 2A is available.
Once. What is it?
The order complaint
page
is an
16.
interim order in miscellaneous first appeal.
An order of status quo, my lord, passed in a miscellaneous first appeal filed by the complainant. But as against, my lord, the order passed by the trial court granting injunction. My lord, the learned single judge, after hearing both the parties concerned, my lord, passes an order as status quo. Thereafter, my lord, there is alienation of the properties, not a violation of, my lord, the orders of. The order which is brought under the contempt jurisdiction invoking the provisions of Contempt of Courts Act 1971 is dated 12/10/23, passed by learned single judge, passed by the coordinate bench, passed by the learned single judge. Admittedly, the order is an interim order passed in the pending proceedings of miscellaneous first appeal. Full stop. Since the order is interim in nature, rights of the parties are not finally crystallized, the parent proceedings of appeal are pending to be considered on their merits. Not only that, in any view, not only that, in any view, the petitioner has remedy under order 39 rule 2 capital A of the Code of Civil
With great
Procedure
respect, I'm sorry
filing
to.
an application for breach of injunction. For all the aforesaid reasons, the court is not inclined to entertain the contempt petition, this contempt petition disposed of accordingly without going into the merits of.
I'm sorry to submit this. That was an order of status quo passed on an application filed under order 41 rule 5. May my lord bring it to my lord's notice the provisions of order 39 rule 2A. My lord, order my lord to be passed under 39 rules 1 and 2, my lord, is only breach of my lord could be alleged under 2A, not an application that is my lord under order 41 rule 5. So therefore, my lord, the breach, my lord, is as contemplated under rule 2A may not be available to me, my lord says.
That you contain. This is the order. Next.
For complaint.
My lords, Saguli chit has been issued, compliance affidavit has been filed, my lords.
I have received only mail regarding this. Your lordship, I have received only mail in this regard, but he has original Saguli chit has to be issued to the party.
Before the council complies with the order,
You have to comply with your button. You comply with your button of the short, then we'll take up. Come in discipline and proper dress before the court. Yes. To be listed on 30th.
Please, Marana Shetty.
For the petitioner in serial number 37, ma'am.
My lord, in serial number 37.1, I am appearing for respondent number 5, my lord.
This is also writ petition or contempt.
My lord, this is a petition that we've preferred challenging a couple of amendments that have been passed by the KERC to the conditions of supply.
This is that.
Filing my affidavit.
Yes, my lord.
I am for the commission. I am filing my affidavit, my lord, which was directed by this court.
So file, learned. senior-
heard
We've
the
been
copy,
served
I'm
with a
filing
copy,
now.
ma'am.
Namgan copy.
Learned, your senior advocate, learned senior advocate, Mr. So and so files. Statement of objections come may be in reply, which may be taken on record, put upon.
Lord, may I make a request?
Pardon, yes.
The connected matter,
Only in the
I
first
do not
part.
know, my lord, how it is connected with this. Is the case where this honorable court has taken suo moto notice of the illegal constructions in the city and has constituted a committee, reports have been submitted. Now, the government had taken time.
This is about that amendment in the provision.
No, my lord, I am nothing to, in the connected matter, is a suo moto writ petition lodged by, registered by this honorable. I am assisting this honorable court by bringing various reports filed before the, now those reports will have to be considered. At one point in time, the government, this honorable court directed the government to effect recruitment because they pleaded that they had no sufficient number of staff to effect demolition of unauthorized construction. Karnataka Public Service Commission was roped in also. Last time somebody appeared for the Karnataka Public Service Commission, they had to inform as to what is the status of the recruitment that they have undertaken.
My lord,
It could be considered separately for this reason, my lord. Some progress can be made in that. If they have recruited somebody, the demolition has to commence.
my lord, in serial number 37.1, I am appearing for respondent number 5, my lord.
That is the KPSC.
Lord, learned advocate last time appeared online, your lordship directed him to come before the court.
I will physically appear, my lord, next time.
My lord, if I may be allowed to make one submission, and for the petitioner in serial number 37, on the point as to why this matter was tagged along with the suo motu petition in 41517 of 2019. It is our allegation in our petition that it fuels an illegal construction in the city. The amendments that have been carried out to the conditions of supply. It is noting this, and we have also relied upon the orders of this honorable court in WP 41517. It is taking consideration of this that the matters had been tagged with one another.
Urgent, serial number 39. The GR Mohan.
appear for the petitioner. In this matter, your lordship, have filed IA-1 of 24. Along with that, I have enclosed the sketch also, your lordship. IA-1 of 24 filed on 1st March, and the sketch was filed because this court wanted to.
My lord, this is a matter where my learned friend is asking for the extension of road. My lords have held that PIL will not survive in making of roads and the extension of roads. My lord, I may please the. This is the same, on the same subject matter, my lord, where the petitioner is asking for a realignment of a road. Yes, my lord.
So because other prayers I am not pressing. By virtue of that, if they restrict to that, it can be realignment, it can be looked into. Immediately after vacation, lordship. Immediately after vacation.
May I request,
Please.
my lord, there's an oral direction from this honorable court, my lord, that I should not allot any vendors, because for what we have done, my lord, this is the Gandhi Bazaar main road, where we have realigned the entire stretch for organizing these vendors, my lord. Or that at least, my lord, if. Much
Please,
obliged.
sir. Because section 232 is basically provides, because yesterday on matter I referred that provision. That if any accident and other things happen in ambulance, so that is only let them address that it can be solved.
40 agents, number 41, stature story.
In this matter, my lords, the state has filed objections, my lord. We have to file a rejoinder, my lord, maybe adjourned by a short accommodation immediately after vacation.
So 41.
I appear for the appellant in this matter, my lords. I filed an application for restoration of the appeal. There was a preemptory order to correct the office objections, my lords. Due to the translation, delay in translation, I couldn't know that there was a preemptory attachment. It has to be restored, my lords. It has to be restored, and I will comply with the office objections. One is for condonation of delay in filing the application for restoration, my lords. 23 days, my lords.
Notice, madam, 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 madam. Can I make a mention? Can I make a mention?
A date may kindly be fixed to comply with the office order objections, my lords. Please, grateful.
To make one mention, permitted minutes, can I make one request? Look, serial number 97, they are the batch matter. Notices have to go, please. Is at that stage only. There are some office objections in some of the petitions, my lords, I will remove them, but notices will have to go, please. Batch matters. Delays there, please. And few of them delays. Sorry.
Court officer. Court officer.
Court officer, Your Honor, I have handed over a copy of the memo that I filed yesterday with the Honorable Court to the respondent, stating that the legal procedure has been followed. And with regards to the urgency for receiving the interim relief, I just wanted to make few legal points to the Honorable Court. Your Honor, interim prayer point O in the writ appeal is for filing the original suit with this Honorable High Court of Karnataka. The Honorable High Court has already recognized the breach of patent cooperation treaty committed by United States Patent and Trademark Office. So I would want to, that is the interim relief prayer or prayer O, which is requesting the orders of the Honorable Court for the filing section of the High Court of Karnataka, so that of my invention and its valuation, especially when we factor in the thermal insulation exemplary application, Your Honor. So when this kind of liability that is caused to United States Patent and Trademark Office is riding on one person, that is me, I requested the Honorable Court with prayer point P and Q to provide the necessary security. One is the physical security and second is the data security. Because, my security, personal security translates to India's, wealth and national security and economic security. Your Honor, prayer points R to CC are investigation related prayer points to be conducted before the execution of the 62 cell agreements, one each with each of the 62 world countries, where I have invention patent rights according to Patent Cooperation Treaty as recognized by this Honorable Court. Your Honor, for the conducting this investigation and ensuring neutralizing all the negative tactics that my public enemies have used against me, these investigations could take 2 months or 4 months. I have no idea how much time the Honorable Court is going to give the respondent to conduct these investigations, which is why the interim relief orders I request are to be granted the earliest. And within this, I have also introduced the concept of the internal cage and external cage with the usage of serum technology against target subjects. There is So that is also one of the investigation point that has been requested in the prayer points R to CC. And there is also the subject of the external cage, investigation of the houses around my residential area, which is also part of the investigation that to be conducted for prayer points R to CC. So, given the fact that these investigations, the Honorable Court might grant the respondent 2 months or 4 months or whatever the time frame the court deems appropriate, I request the Honorable Court to kindly grant this at the earliest, these orders. And the prayer point DD is for the independent valuation of the respondent, Indian central government to present their own independent valuation of my invention and its overall sale price combined across the 62 countries, Your Honor. So for that, once again, it is the Honorable Court, if deems appropriate, to give them few months for conducting this investigation. These orders be granted immediately and at the earliest.
Your petition is listed at which serial number?
WA 983 of 2024, Your Honor.
WA
983 of 2024.
24. Which number it is listed today?
Yeah, today you had given the date of today, 24th. It was not on the list, but I wanted to share the urgency for the interim relief because you had
today not listed.
It is not listed today, Your Honor.
Then
But then when I presented the memo for posting earlier, you had given me the date of
to you in the morning that once the date is given by judicial order, if you want to prepone it, you have to file interim application. By memo, it can't be preponed. So that is already told to you in the morning at 11 in so many words, and it was made as clear as daylight that you can't argue in this fashion.
I wanted to
Want to
share.
prepone the date, file an interim application, making out an urgency for preponement.
I thought when you granted the 24th date with the memo for posting, I thought it was to be posted for orders today, which is why I came here, Your Honor. So
We thought we were not audible to you in the morning. So we are today speaking right now in the second half, we are speaking loudly
No, Your Honor.
to make you the audible, that you can't argue a matter which is not on board. And if you want to preponement of the date, file interim application. By memo, we will not. And nobody is filing memo.
I just wanted to share the urgency for the interim orders. That's
We have shared our order. That is our order. You have to file interim application. You can't argue like this and waste court of the time. Right?
yes. So I must wait until the 24th of October.
If you want to prepone the matter, file interim application. We'll see whether it can be preponed. Correct.
Please, my lord.
Serial number 70, my lord.
Yes.
Serial number 70.
70.
I am for the complainant in this matter, my lord.
Pardon?
My lord, sir, there's a personal inconvenience, my lord. They are as a personal.
So it will go to.
May I please request it to be taken on
25th.
14th or 21st, please, my lord.
Pardon?
14th or 21st of next month, please, my lord.
14th.
14th or 21st.
14 is first day.
It's on Monday.
We'll say 21st.
21st, please.
21st. 10 over to 21st as requested by law and
Okay.
counsel for the parties. Yes.
Passover matter, list number 2, seal number 1. Mr. Prasanna Deshpande.
Sit. Let's firstly, I'm sorry, my lords, morning request was made for a Passover.
You made a request, not sure.
This, my lords, the only request was whether we could be permitted for counseling, to attend the counseling.
That.
Council
That's the-
can always attend,
No,
not.
but that's with the reservation, that's the only, otherwise, my lords, I'm sorry, when this is a case where we claim reservation and
The government has to take it. The first thing, my lord, they have to, that particular religious community have to establish an institution. There are no institution established by the Jain community, my lord, as far as medical and dental are concerned. In Karnataka, my lord, only Christian and Muslim minority institutions are there. Only they, my lord, as far as Jains are concerned, they can't fit in, my lord, in those minority institutions. They become aliens. There also they can go, but as a, my lord, general candidates, not as a minority candidates. That is what, my lord, the Supreme Court has said in.
that, of course, my lords, I can't. But the Act says, my lords, it shall be subject to reservation policy. My lords, that's why, my lords, I said I apologize because it was. Some day, let them come, because the state has said they'll come out with a. No, my lords, not me. My lords, your lordship may let them file their counter in that
We'll
case.
file our
my lords.
counters. Please. Yes.
Once again, my apology. I think morning they.
List number 1, seal number 108 for withdrawal, contempt, to Gangadharaya AN.
Subsequent to issuance of notice, my lord, order of single judge was complied by the respondents, my lord. I have no grievances to state against. Oblige, my lord.
This is serial number 109 to Praveen S.
For the complainant, my lordship, the order was, as soon as the notice was received by the respondents, been done, my lordship. Have been complied with the orders, my lords.
Number 110.
Same, my lordship. Appear for the complainant. Same, my lordship.
Serial number 111, Mr. Pradeep Nayak.
Much obliged.
Here for the petition, Lord, and for the respondent, my Lord, a request for my Lord, pass over, my Lord. Mr. Advocate General appears in this case, my Lord. Mr. Advocate General appears in this case. But seek for pass over, my Lord.
The trees.
Trees. He's held up, my Lord, he's coming. Please,
27th.
27.
he's coming, my Lord, he's at 2 minutes. There's an extreme urgency, my Lord. Every day, my Lord, there's loss of 8.32 lakhs, my Lord, per day, my Lord. Public money.
Would your
I'll
lordship
take a chance, my Lord. Pass over. If it, my Lord, convenient, my Lord, it can. Okay. Please, my Lord. Please, my Lord.
would your lordships have it at 2:30 again, Manoj?
2:30.
Please. At the convenience of the court. Please. Please. I also want to point out, Manoj, on the last occasion, I have filed a convenience compilation with all of the orders passed in a summary, Manoj. Please. Deeply obliged.
Serial number 112. Mr. Muralidhar Rao, party in person.
We are for respondent number 3.
Good afternoon, Your Honor. Firstly, thanks for allocating this first slot of the afternoon for me, Your Honor. Now, firstly, thanks for allocating this first slot of the afternoon for me, Your Honor.
We never accept any thanks from the clients.
Okay, thank you.
This is court of law. We are not exchanging pleasantries, Mr. Party in
Oh,
person.
I didn't know that.
Be your in limit.
Okay. Now,
This is
while
court
the-
of law, not the
Oh.
place of exchanging pleasantries.
Fair enough.
Proceed with the your matter.
Yes, now while the respondent, learned respondent lawyer had submitted his a response to the petition, there are certain points that I would like to highlight, Your Honor. Now, the financials of the government, it was mentioned. The difficult financial situation of the government with respect to the dues to the government, now, here I have filed in the memo also the excerpt from the Deccan Herald of 8th August. It says the supplement, out of the cumulative loss of 23,287.37 crores up to end 21-22 suffered by the state-run companies, 51% was contributed by ESCOMs. So, and further, it goes on to say the difficult position it's mentioned. According to the latest controller CAG report, the government has provided a guarantee of 52,335.74 crores for borrowings of electricity supply companies and the Karnataka Power Corporation. This could be a ticking time bomb, as the CAG warned eventually of the entire liability could fall on the state government, given the losses being incurred by the ESCOMs. So that counters the point made by the learned lawyer about the financial position of the ESCOMs. Now, about coming to this accident aspect, there was again a report on 19th August, Deccan Herald, about, it reports the order issued by the court here itself. Justice Nagbhushan bench. They also relied upon report of the electrical inspectorate, which held the incident had happened due to high impedance surface for which no wrongdoing on the directly can be attributed to the petitioners. On the other hand, the state public prosecutor submitted that the act of allowing the wire on the street is attributable to some officers, and the 5 of them have been named as accused. He further submitted that everybody cannot wash their hands off on the basis of a report of an officer of the electrical inspectorate, who is an officer of BESCOM. So here again, on the matter of accidents due to criminal negligence on the part of the official of the BESCOM. In contrast, Your Honor, in the petition Annexure C, there is this tabulation highlighting the performance of the Delhi DISCOMs, and on all counts, it is far, far superior to what BESCOM is currently operating at. And this is with 100% reliable power supply and far lower tariffs than being charged by BESCOM, and even with 200 units being given free to the poor consumers. So on all counts, it's a fantastic, phenomenal performance. And there was the learned lawyer had mentioned about privatization having its own problems. But Your Honor, this is a PPP model. like I had mentioned earlier also, it's where 49% of the equity is held by the government of Delhi and 51% by the private player. And that has made the performance so excellent by world standards. Privatization has had a negative connotation all this while, but that has been the problem with privatization practices all this while, largely because of what has been termed as crony capitalism. But this is a totally different model and which can be replicated across all entities where government's role is required. And with a Delhi Electricity Regulation Commission in place to oversee the whole job. And there was this mention of and for lack of, because of poor power supply, the diesel consumption figures I had given you, 11 million liters of diesel. Here, the Decadal report, which I had submitted, corroborates that, Your Honor. Here, I had submitted in the memo, and it corroborates every bit of what I had stated. And it's a huge pollution problem. And that is where I have made the State Pollution Control Board also a respondent. And because of this poor power supply, it is the poorer people who are suffering the most, Your Honor. Whereas the middle class and upper middle class can afford all kinds of alternatives. It is the poor who have to suffer the vagaries of the monsoon, the summer, all of that. And even the business class, you would have noticed every business establishment, all of Bangalore, you will first see the diesel genset right in front, making a noise and belching out smoke. And even as if this court is functioning, possibly, I don't know, I'm not sure whether we are getting the BESCOM supply or it's a diesel generator power supply. Your Honor, I had been in the electrical industry I am basically an electrical engineer. I was running a manufacturing unit, supplying to the electrical industry. All of BHEL, Crompton Greaves, Alstom, etc. were all my customers. And they were in turn supplying to the electricity boards. Electricity boards even today as then are totally bankrupt. And that is why I had to pull out of my business. And even today, the situation continues the same way. And that is why I have taken up this challenge of correcting this whole situation for the benefit of the future generation, Your Honor. For the benefit of this, yes, of the city.
That's all.
I pray that the order be passed early, Your Honor. Thank you.
You file your counter? Where is that? Not filed. All right. So what is your submission?
Basically, the party in person is seeking a relief of privatization of the electricity.
Privatization of
The electrical supplies.
electric.
Yes, Your Worship. That is at para 2, in view of the fact that the state has not been able to do so all these years, as suggested above, a writ of mandamus to the government of Karnataka to seriously reconsider restructuring the entire distribution system in a state perhaps along the most successful and equitable Delhi, Odisha models, as already stated in serial number 22 above. In fact, a few years ago, if you were to go on the KREC website, it mentioned the Karnataka government itself having committed to privatization of distribution. Well, by virtue of a public interest litigation, the party in person cannot enter into the domain of administration of the state powers, Your Lordship. Regarding the first prayer, what he has sought, Your Lordship, regarding the safety and other things, BESCOM is committed to that. In fact, the representation that he had given have been considered by the Karnataka Electricity Regulatory Committee and directed for the ESCOMs to consider his request, and that has been answered regarding the safety and supply. If that, his representation has been considered on that effect, Your Lordship. The other thing remains is that the privatization, that by virtue of a public interest litigation, that he cannot enter into the domain of administrative powers of the state, Your Lordship. That is the.
But if I may submit, I had mentioned that the Karnataka government itself on its website had mentioned years back, almost decades back, that, while restructuring the whole, the power sector, the whole idea of restructuring the power sector was also, it had also mentioned that the distribution will be privatized. But now, of course, subsequently, all kinds of lobbies are acting and pulling this way and that way, and that entry in this thing has been removed. But look at it, Your Honor. I mean, even yesterday there was a report in the paper, in the press, about how Orissa is now remodeling and it's working out very well. And the tech capital of the country, Your Honor, okay, we are suffering this poor quality of power supply. It's untenable, Your Honor, and it's been too long going on this way. They talk about, these accidents. Only the egregious ones have been reported. There are so many on a regular basis that are happening, and it just goes unnoticed even. On a regular basis, there are so many. And even in that Whitefield case, where the mother and child were burnt alive, it was because of plain negligence. The fault had been reported by the Resident Welfare Association locally to the thing. They didn't bother to rectify it. And this happened. The wire just was on this thing. The lady walked on it in the morning, just getting out of a bus, stepped on it, and she and her child were burnt alive, Your Honor. This can happen to any of us, Your Honor. And I think it is time we put a stop to it. Such incidents are never ever, have not been happening in the countries where privatization has happened. Yes, privatization. Yes, I told you, privatization has a negative has been having. That is where this Delhi model has been an exemplary model.
Why don't you sit down till the arguments are over?
Yes.
It is for him, not for you. You continue.
Yes, that's what I said, Your Honor. So, it is high time. We cannot get the city and the state cannot afford this any longer. And you saw this in the World Bank and the other reports. The losses are huge, and many other services are suffering on account of this, Your Honor.
Yes.
While simultaneously the Delhi discoms are making a profit, giving dividends on the strength of which the Delhi government is doing a lot of good work. So that is how it should happen here. Here it's a burden, not only on the state, on the citizens also, Your Honor. You appreciate in your own city, Your Honor, in your state, you have excellent power, you know that. And why can't we have that here also? It is simple. It can happen in what has happened in Delhi, the transformation. It can happen here in just months. Every point that the respondent has seen, I have given my counter to that. And I don't think, there is nothing more to say, Your Honor. It is just very plain and simple. It's an open shut case, I would think. And about the jurisdiction of, that's a matter, but because of some such thing, the city and the state should not be suffering like this, and the people of the city, and also particularly the poor. And the amount of pollution, like I told you, 11 million liters of diesel being burnt up every year, and just by the domestic sector.
It's,
That is all. Anything further?
I think that's more or less what I had wanted to say, Your Honor. Thank you.
I appear for BESCOM in this matter. I filed my counter on 25th of June, 2024.
25th of June.
Yes, ma'am.
Ah,
Hello.
yes.
The first contention that I would like to raise is regarding maintainability of the writ petition. Ultimately, the prayer that is being sought is a policy decision that will have to be taken by the state.
What is your good name?
Pradyumna.
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 Or?
BESCOM, respondent number 3.
Yes. So, maintainable.
Ultimately, it's a policy decision is my respectful submission. And regarding Annexure C that the party in person pointed out, may I request your lordships to kindly take page 21 of the petition. Just to show that the comparison that he's making BESCOM and the Delhi DISCOM, it's really without logic. It's something that I'll have to demonstrate. 21, my lord, Annexure C, last but one line. The number of consumers, it says 15.8 lakhs. In comparison with this, BESCOM caters to crores of consumers. So this comparison that is being made is unfair.
May I respond to that point, Your Honor?
Let me come.
Okay.
And even prior to the filing of this petition, he had submitted representations. We have considered them. We have even issued a reply to him regarding the various safety measures that we have been undertaking. That is also at Annexure R2 of the petition, my lord. He has produced it. That is the consideration of his representation. I've stated the various measures and also the fact that every third Saturday of every month is being observed as Safety Day to spread the awareness among the general public. Annexure R2 at page number 44, my lord.
That is all.
Lord, along with my statement of objections, I have produced 4 documents which show the amount of investment that is being made by BESCOM towards development of the infrastructure, be it safety, be it efficiency in distribution, the number of the measures that we are taking. I have produced it from Annexure R1 to R4, ma'am. And may I request your lordships to kindly take Annexure R4 at page number 27. This is the average power supply that is being given in industrial areas, agricultural, urban. I've given a separate table of all 3 categories. The average is around 23 hours and 51 minutes as on 2023, my lord. These are the official figures. So the complaint that is being raised by the party in person, I not sustain is my respectful submission. I have produced it from the year 2018, 2019 up to 2023, which shows the increase in the average power supply every year. And sometimes there may be some disruption in the supply of electricity due to reasons that are beyond our control, my lord. I have produced the details of that also in page 26 of my objections.
That is all. You're teaching some arguments.
No, my lord. Annexure R3 is something that is beyond our control, my lord. Sometimes that happens.
I would like to respond to a few points, Your Honor. He said a number of consumers. Yes, Delhi is a state, it's a city. Now, likewise, Bangalore. Bangalore is, I think, about half the size of Delhi, or maybe about 3/4 the size. Now, exactly, that's the problem. Now, when BESCOM, it covers not just Bangalore, it covers Chitradurga, Kolar, and all of these places. And then all of these places, district, rural areas, it is largely the rural and the agricultural load. And there, up to 10 HP, there is no metering even. So there is, I mean, these kinds of figures that they pull out are just out of the, there is no proper measurement even, because there is no metering even for loads less than 10 HP. So that is where the problem is. Now the rural roads are different and city loads are different, so they have to be segregated, and that is exactly what now Odisha is doing. Yes, different. Delhi is different, Odisha is doing. Odisha is doing exactly that. And that is the model they should be following here also.
Delhi is better or Orissa is better?
Now, Delhi started this process in 2002. Sheila Dikshit government started it. Okay, and over the years, it has come to a level where, you see this. So he talked about, 23 hours, something, etc. In Delhi and other places, particularly where it is covered by.
Gujarat is also better.
Pardon, Your Honor?
Gujarat is also better. Gujarat is.
Gujarat also. Yes, I mean, he talked about 23 hours, few minutes, etc. In these places, there is no question of this breakdown at all. And of course, there will be some maintenance. They give you advance notice. That happens once in a year at best. Your Lordship, my in-laws live in Mumbai, and they live on the top of a seventh floor. And that building doesn't have a genset. So if there is power supply, they have to walk up. They haven't had to do that ever. And that is the situation in most of these cities. Here, can you think of any building, any high-rise building without a genset? Not just high-rise. Even here, I am not very sure if you are getting BESCOM supply or genset supply. So that is the point. And about accidents, there was, I mean, I must, and also about these pictures I have added as annexure, this thing of the changes, what was earlier, what is now, after the privatization has happened. You can see if you, this preventive maintenance, and if you structure it properly, you won't even have, there won't be any breakdowns at all, which is what is not happening here. Look at the differences, the difference that has happened after privatization. Yes, privatization, like I said, yes, the privatization has had a negative connotation, but here this model is totally different, Your Honor.
So that is all?
Pardon?
Anything further?
So all of these points and the financial situation, Your Honor, it is,
Hmm.
I must specifically mention this particular serial number 19 of my submission. These are besides leaving DISCOMs totally incapacitated to pay their main supplier, Karnataka Power Corporation Limited, evidenced by the fact that Karnataka Power Corporation balance sheet for the year ended March 31st, 2020, the latest that is available on the website.
You want the other side to argue again?
Pardon, Your Honor?
You want the other side to argue again and again?
No, I'll just this point and then I'll.
Then complete it.
Yeah, I'll just this point. I'll finish and then. Yeah. Shows the receivables at 17,571 crores, more than twice the income of the year, which is at 9,597 crores. The receivables are double the annual income. Now, what kind of which would have earned the company a label as a non-performing asset multiple times over, if not for the government guarantee. Now, yes, government guarantee, you saw what the World Bank had to say, and guaranteeing all these operations at the cost of the taxpayer, it's no longer tenable, Your Honor. I think it's high time government gives up this job and gives it to people who can do a better job.
Hard learned party in person, Mr. Muralidhar Rao, son of late Sri B. Govinda Rao. Coma learned additional government advocate, Mr. Jafar Shah, for respond number 1 state. And learned advocate.
Point number 2, absolutely.
Mister, what's the good
Point
name?
P and Prakash. That's point number 2.
What's the good name?
Commission. I have, only thing is
For learned Ravi Prakash, for respond to Karnataka electricity.
regulatory group.
And learned advocate, Mr.
Pradyumna KV.
Pradyumna K.
KV.
For respond number 3. For pollution control board, somebody will appear? Nobody. And learned advocate, Mr. Mahesh Chaudhary. In absence. For respond number 4. Tell that his name is being written. Learned advocate Mahesh Chaudhary for 1-4. At length. At length.
Okay.
Reserved for judgment.
You can
Judgment
take a
will-
quick poll here also as to who they support, Your Honor. You can take a quick poll here as to who they will support, the public will support.
Yeah. Now you leave to us. Now it is for reserved for judgment.
Thank you, Your Honor.
Your role is over, our headache starts. Yes, so. Whosoever, whose name? That prison matter.
Yes, my lord. My lord, if it could be had after vacation. Learned additional advocate general, Mr. Vijay Kumar will be appearing. Lord, may have it on the 14th itself, 14th or 15th.
No. Twenty-second.
Obliged. My lord, I have complied with my lord's
Now,
direction.
At some point of time, this has to proceed.
My lord, I'm just trying to get a few decisions, my lord, where I can resist this grant of parole as a matter of right. Because many of them, my lord, to whom the parole has been granted, my lord, there are offenses that are committed by them.
So this might turn out to be very important.
Yes.
Come on 22nd. Anything to be, replies to be filed?
My lord, I'd just like to do a little bit of research and then get back to my lord on 22nd.
If any pleadings are to be filed in terms of the
My lord, on 22nd, I'll make a submission.
reply, same shall be filed before the next, shall invariably filed before the next. If to be filed.
No, I thought I could make my submission with
If
the
any reply
citations.
is required to be filed by the respondents, it shall be filed before the next date.
Obliged.
It is 22nd of October. March.
For list number 3 for pronouncement of judgment. Mr. R.G. Kolle.
For the petitioner. For the petitioners.
So both the petitions are dealt with together since they know all the common facts and identical issues.
Please, madam.
Applications dated 20/12/23 for renewal of lease granted under the lease deed dated 25/3/2006 was not maintainable as not filed 90 days before the expiry of the lease period of 5 years. The application dated 20/12/23 is hit by delay and latches. The renewal of quarry lease license is hit by timeline under sub-rule 2 of Rule 21 of KMCC Rules 1994. Sub-rule 8 to Rule 80 of KMCR Rules 1994 is not applicable to building stone as it is not part of the notification dated 10/2/2015. Accordingly, both writ petitions are dismissed.
Obliged.
Please.
List number 1, symbol 43. Srimati Pratima Iske.
I just received. I just received one communication by them saying that they want one more application by the complainant, my lord, to consider the representation. I do not know how that can be.
Directed to address the grievances, consider the representative. Not consider.
Plus, it's not, they want one more, they have issued a letter to the complainant saying to give one more application.
Why?
Now, this is nothing but delaying tactics, I would submit, my lords.
Who appeared?
Murgesh Charity.
He's coming. He's coming. But in the meanwhile.
Who is come?
Lordship Senior is coming. He's just climbing stairs in a minute.
I apologize. Take rest.
Not, we have, should an endorsement.
If you have not complied with, take rest.
We have complied. May I pass on? May I pass? Not earlier, the direction of the learned single judge was to consider the representation.
You copy to your learned.
Please, I have permission.
So the complainant is claiming some allotment.
Yes.
Well, of the annexures that they have produced, let's, if I may just request your lordships to turn to the translated copy that they have produced, my lords. Here, they refer to the representation given by the complainant, two representations. Now, irrespective of that, finally, what they're asking is, please give one more application for us to consider the allotment.
What we have said is, you will have to file an application as per the rules of the Bangalore Development Authority. Then we will
This cancellation notification is issued.
Please.
Cancellation notification is issued.
cancellation order is passed not on 18/7/24 itself. Not I had produced this before the
Issued.
Honorable Court.
Issued.
Please, cancellation order is passed. And subsequently, your lordships, with regard to their allotment, I was.
16/7/24.
Please. And with regard to their claim for allotment, Lord, I was required to decide. Lord, we have said they'll have to file an application under the rules. Okay.
Yes, this has already been replied by the complainant saying that there is already a representation, and that's exactly why they have approached the court, because they did not consider that, and in the writ petition that was allowed, my lords.
Will not be
But now as per their policy, they are inviting application.
applications.
They've already finished making an application long back, and that is not considered, and that is the reason they approached the
It is a
Honorable High Court. But now they're saying to again issue, that makes
There might be other takers.
There is a format, Lord, they'll have to comply with certain conditions of allotment. Not the rule prescribes.
No, they maybe,
They have,
they are saying that application is already made.
already been made,
no,
yes.
what happens is I call for an application from the general public. Not only they, other will also have to participate. And then I'll have to see as to who fits into the requirements of that
So there
locality.
is some policy.
Selection process is there.
Where is that?
Under the allotment of CA site rules,
Some circular is there, rule is there.
the rule is there.
That is.
Rule of the Bangalore, BD allotment of civic community site rules is there. No?
Yes, he's, in fact, my lords, he's speaking about CA site allotment rules in respect of the public. Here it is a private layout. That also is prescribed. And in the private layout, the CA amenity site, which has been relinquished to the authority, the BDA, the registered association of that layout, they are entitled for that. Of course, on a lease agreement, my lords,
That is.
for a certain number of years.
That is to the layouts which are approved after 2007. That is a revised master plan under the revised master plan rules. Those who are approved after 2007, they'll be entitled for the benefit. Here the case, this layout was approved in the year 2004, much prior to the revised master plan coming into force. The approval was granted on 29/5/2004. Revised master plan came into existence from 2007. So what happens is all the civic amenity sites will have to be relinquished. And there is a relinquishment deed in favor of the BDA. That's a undisputed fact. So the BDA will choose who is the best suited one among the applicants who file their applications. Lord, may I request your lordships to kindly take the Bangalore Development Authority civic community, BDA allotment of civic community site rules. BDA rules. 1989.
Rule number is.
Rule, Lord, page, rule 3, Lord. Rule 3 speaks about, Lord, the offer of the civic amenity site for allotment. And Rule 5 speaks about registration. Rule 6 eligibility, Lord.
So this applies to the private sites also.
Yes, Lord. Private layouts, they relinquish their CA sites and open spaces to us. Not insofar as CA sites are concerned, Lord, we'll have to do it by a method of selection. Rule 7 would.
What can be done? You challenge it.
Let's, in view of the cancellation that they have done, they are bound to consider my representation, which is the main grievance that the association had. And for which reason they had approached the High Court in WP so and so. Now, they can't be asking for one more representation by the complainant, my lord. That would be a futile exercise, I would say. And nothing but to drag on the matter. Because when already a representation has been given and dates have been mentioned by them itself, I don't see any reason why they can't consider that. And I can produce the relevant rule, my lord, wherein it says. Also-
Sorry, contempt petition number 435. 23. Learn a single judge while disposing of the writ petition. Passed order dated 8th November 22, whereby the respondent authorities were directed to address the grievances of the petitioner associates and consider their representations dated 5/9/2019 and 7/12/2020 and pass appropriate order in accordance with law within stipulated time. The aforesaid direction to consider the representation and pass the order was passed in the context of the prayer of the petitioner before learn a single judge, whereby direction was asked for. Direction was sought for from Respondent 1 Bangalore Development Authority to hand over the civil amenity site CA1 situated in Chaitanya Samarpana layout in survey number 154 and 155, Kanna Mangala village, Bidarhalli, Hobli. Full stop. Pursuant to issuance of paragraph notice in the present proceedings, learned advocate, Mr. So and so, for Dispatch number 1 Bangalore Development Authority has filed memo dated 28/8/24, along with which copy of the endorsement dated 27/8/24 issued by a state officer, Bangalore Development Authority, Bangalore, is produced. Therein, two main aspects are stated. Firstly, that allotment of CA number 01 of Chaitanya Samarpana layout, which was allotted in favor of Messer Chaitanya Samarpana Owners Welfare Association.
Not owners, my lords, just welfare, earlier.
Chaitanya Samarpana Owners Welfare Association.
That is a mistake. Earlier, it was just welfare association. It was not the owners.
This is correct.
There is a mistake made by them.
Samarpana Welfare Association
Yes. my lords.
has been cancelled. And necessary notification dated 16/7/24 is issued. It is stated that Bangalore Development Authority Civic Amenity Site Allotment Rules 1989 would operate, and thereunder it is secondly stated that, and thereunder the application shall be invited, and if the application is submitted by the petitioner association, the same would be considered for allotment as per eligibility. While learned advocate for the respondent would submit that the aforesaid endorsement of legal order amounts to compliance of the direction from a learned advocate, Ms. So and so for the complainant stated that it does not amount to compliance inasmuch as the authority has invited a second application which is uncalled for. It was submitted that one application was already made by the petitioner, which is liable to be considered, and the petitioner deserves to be allotted the site. Full stop. As noted above, the directions of learned single judge was to consider the representation of the petitioner and pass appropriate order. Full stop. The representation is considered. Full stop. The authority has proceeded to cancel the earlier allotment. Thereafter, if in compliance of the Bangalore Development Authority into bracket allotment of civic amenity sites, bracket over rules 1989, respondent is to invite applications and consider the case of the petitioner for allotment of site if the petitioner has applied, as per eligibility, it could not be said that thereby any willful contempt is committed by any of the respondents. Full stop. The contention raised by paragraph learned petitioner that application could not have been invited for, and the allotment should have been straightway made in favor of the petitioner, cannot be the subject matter of domain of the contempt jurisdiction when the direction to consider the representation is acted upon and the representation is decided in the aforesaid manner. So the contempt proceedings does not survive, as no contempt could be said to have been committed. Any of the endorsement passed, full stop. any further grievance paragraph. It is observed that any further grievance which may survive in, if survives in favor, if survives for the petitioner, comment will be open for the petitioner to institute independent proceedings seeking relief in respect of which recourse and in respect of such subject matter. This court does not express any opinion on merits.
Number 44, T.N. Suresh.
Counsel for complainant, my lord.
Lord, there was a direction, my lord, that.
Counsel
Page
for
18.
complainant, my lord.
Okay,
My lord.
it is complied with.
Oh, complaint, I am the complaint. They have not given.
Not
they have
complied.
Complied the order. That's why I'm telling, see, my personal property, they have utilized for BBMP officials 34 years back to construct a wall to the Rishabhavati Valley. So after that, they are given one acknowledgement. This honorable court have passed the order on 23/5/2023 under WP number 25/568 dated 22, given 3 months time to give alternative site. It passed, order is passed 1.5 years ago. And also they have taken 5-6 times to compare the order. They have not filed so far. See, it is already 34 years. My personal property they have taken, my lord. This is my case.
But we had allotted a site to him, my lord, but that site, my lord, was in a park. So we are searching for an alternative site, my lord. By this 2 weeks, my lord, we will search for an alternative site, and my lord, I will hand over.
This is the 7th time they are taking time, my lord.
Sorry, my lord.
My mother died and my age is 65. My son is actually, it is already 3 generations, 3 decades.
So you're not given any site?
No, my lord. One given recently,
One
that
site
also they were saying, annexure number K, they have given an endorsement. Kindly
Lord,
Kindly
this-
permit me to read
Lord,
page
we
number
filed an
62, my lord.
affidavit, my lord, to that extent, my lord, where the site which was allotted to him, my lord, was a form of a park. We are searching for a site, my lord. We have also written to all the zonal revenue officers to come out with a site which is vacant and litigation free, my lord. Kindly request for 2 weeks' time, my lord,
We'll grant you.
I'm
but
requesting,
For compliance.
yes.
Otherwise, who is the person?
I request this honorable court kindly, it may be given, it may be directed to the commissioner to come to the next date to this out. They are not taking seriously since 34 years. That is my request, my lord.
You want commissioner to remain present or you want site?
I want site. Yes, ma'am.
Let us be clear about.
I want site, my lord. That is my parents.
I request, my lord, I may have also filed this memo, my lord, which
It was a house property.
House property, site.
The house property of the
Yeah, my lord, that is.
of the petition.
residential site.
Yes, ma'am.
It was a residential site.
Residential.
It was a
site,
residential
30 by
site.
35 size.
Residential property
Site.
of the mother of the petitioner was raised RSADD to the ground by the Bangalore City Corporation, then existed from as back as in the year 1992 for the purpose of construction of wall protecting the Purshabhavati
Valley.
water canal. The Lokayukta accepted the grievance of the mother of the petitioner in the year 2003. The petitioner was to be allotted the alternative site. Petitioner had to file writ petition, which culminated into order dated 23rd May 2023. Whereby the earlier it was granted,
Earlier they have granted, it has again they have taken back for purpose of park.
whereby the respondent authority was directed to grant alternative site in place of earlier granted but taken away.
Yes.
The order taking away the earlier allotment was set aside by learned single judge. The aforesaid direction is sought to be complied with by filing this contempt petition. The affidavit in reply filed by the Assistant Revenue Officer, BBMP, Chamrajapet Subdivision, Bengaluru, reveals the facts which only show that the respondent has been apparently evading the allotment of site to the petitioner. Earlier, writ petition number 25568 of 2022 was filed by the complainant, which was disposed of on 23/5/23 by this court, with a direction to the complaint, with the direction to the complainant to file application for grant of the site. It appears that the sites which were granted by the authorities were either used for park or used for civic amenity, or was used for religious activities on the second occasion. Full stop. By acting unrealistically and to deprive the grant to the petitioner complainant, the respondent, PBMC and its officer have been conducting themselves contumaciously. Full stop. Not only that on paragraph, not only that on 5/8/24, in the present proceedings, this court had to pass the following order, quoting the order dated, had to pass the order, quoting the order dated 18/6/24, in which the seriousness of the issue resulting out of non-compliance of the directions by the authority was highlighted. Full stop. When the paragraph proceedings comes up for consideration again, no improvement in the conduct of the respondent is indicated. Full stop. Learned advocate for the BBMC has an audacity to seek further 2 weeks' time, even as the directions have remained bluntly uncomplied with. Full stop. In the circumstances, it is directed that the compliance of the order by immediately identifying and allotting the site to the petitioner shall be obtained and shall be put on record before the court in these proceedings. Stand over to 1st September, 1st October to be listed at 11. Full stop. The non-compliance of the direction on that day will entail stern and serious consequences for the authority concerned of the Bangalore Mahanagarpalika.
Request a date after vacation, my lord. Request a date after vacation, by name, we will for sure comply, my lord. I'm sorry.
All that at this stage, learned advocate for the BBMC fairly stated that some more time may be granted for compliance, full stop. Instead of first, in view of the request, instead of 1st October, comma, the contempt petitions will be listed on 16th October, full stop. It is however directed that if the directions are not complied with and the site is not allotted to the respondent, to the complainant, comma, the commissioner shall personally remain present, either physically or through video conferencing.
Much obliged.
Who will remain present? Who will remain present?
Commissioner, my lord, my lord's order is commissioner, my lord, or the special commissioner is also there.
You tell who will remain present.
Lord, the special commissioner or the executive engineer, my lord.
Who is the concern?
Lord, the Tushar Girinath is the commissioner, my lord, Mr. Tushar.
You tell who will remain present. Who is to comply with?
Lord,
You tell us.
I request Lakshmi, my lord, Srimati Lakshmi, my lord, is the assistant officer.
At this stage, learned advocate for the BBMC stated that Srimati Lakshmi,
Assistant
What is
Assistant
it?
Revenue Officer, Chamrajpet Division. Assistant Revenue Officer, Chamrajpet Division.
no, we want commissioner, Mr. Counsel.
I'm sorry, my lord. Then, my lord, Mr. Tushar Girinath.
We are asking about the commissioner,
I'm sorry, my lord. Mr. Tushar Girinath.
not the estate officer.
Sorry.
Respect the court and the court status of the High Court.
I'm sorry, my lord.
The estate officer is not supposed to come here.
Mr. Tushar Girinath, my lord, is the commissioner.
We will record your statement. At this stage, we record your statement.
Lord,
See that it is complied with.
I will, my lord. Make sure it is
So then
compliant.
write that science and not remaining present. If the order is not compliant with, it will entail stern and serious action for the.
Much
consequence.
obliged.
Yes.
45.
I appear for the complainant.
Done, David.
I appear for the complainant.
For the accused, my lord.
Yes. 45. What is it?
My lords, the order, my lords,
My lords, I'm filing a memo wherein as per the direction of the single bench, my lords, they are supposed to provide us the comprehensive details of all the calculations which they have occurred. We have repeatedly asked them through those letters which are there in my memo for those comprehensive representations, comprehensive reports regarding these expenditures which they have incurred, my lord, which was pre-GST period and after post-GST period. That part of the direction is at page 160 of the contempt petition.
sir, memo.
Whereas when we sent those letters, they've sent us a legal notice inviting us for an arbitration proceedings, my lords. Page 160 of the petition, my lords.
So we permitted them to file GST return without penalty and.
No, my lords, this relates to agreements which was entered between BBMP and the private contractors for works which had to be done pre-GST, my lords. Now with the imposition of GST, their claim is that the cost of the project has increased and therefore BBMP needs to reimburse them as per a certain clause of the agreement. Now they approach a single bench on that basis. Single bench has laid down a methodology of how the calculation needs to be done. It also has given out a direction at page 160. Petitioners are directed to submit comprehensive representation to the respective employers, that is us, within a period of 4 weeks from the
The
date of.
representation, my lords, is at page 163.
We now complied with.
No, my
Comprehensive, it
lords,
is
they have
not
not paid us
comprehensive.
the money, my lords. In terms, the order of the learned single judge, my lords, they'll have to refund the money which is collected pre-GST regime.
Where is that direction?
That direction, my lords, will get it at page 160.
Refund,
Where is the refund?
page 160.
Page
clause 3, my
160,
lords.
clause J, my lords, operative portion, paragraph J.
Are to be paid reimbursed.
Please, my lords.
So what reimbursable amount is there or not?
Please, my
That
lords,
needs to be
page
found out.
165 is the calculation.
That needs to be found out by the methodology which has been laid down by the single judge.
Page
my lords.
165, my lord,
Those
we
are
have
the
provided the
conditions
calculation.
which will have to be followed in the starting of the operation of the order, page 157. If my lordships can go through clause 2 to J, these are the various steps that one needs to
We have made the
inculcate in
calculation.
calculating whether there has been reimbursement.
You are reimbursed some amount? No.
No, my lords, they have not given us any money.
What is yours?
My lords, they have to provide us a comprehensive representation of what is the amount, because it is not just a reimbursement of one single amount, my lords. Detailed calculations which will have to be conducted. If they provide us the comprehensive details of all the expenditure which they have incurred, that will be considered, and whether they're entitled for reimbursement can be looked into, my lords. In fact, the order is not just reimbursement. If there is an excess amount which they've collected, that will also have to be incorporated in the calculations, my lords.
You need to supply in little.
Yes, my lords.
As per A, B, C, D, E, F, G.
My lords,
Page
Para clause 3, Subroman clause 3 is very clear, my lords. Petitions are directed to submit comprehensive representations to the respective employers within a period of 4 weeks from the date of receipt of the copy of this order, irrespective whether they've completed the works pre-GST or pro-GST, post-GST, or payments were received or yet to be received post-GST. If such representations are submitted and respective employers, respondents are directed to consider and dispose of the same in light of the aforesaid directions and guidelines.
my
as
lords, my
expeditious.
calculation, my lords, is at page 165, my lords. The work done pre-GST regime and the post-GST regime, my lords.
My lord, that's just a writing. I mean, we need a calculation.
This
Page
is-
page 165 made looked into as they are suggesting, my lords. It is just a reminder
This-
letter.
No, 165 statement.
This is a statement, my lords, which we have given it to them, page 165.
Then this is only a table. Where is the?
There's nothing, there's a no
supportive-
table in my.
Supportive details, they will need supportive details.
Yes. As per the procedure which is laid down by the
Table
single
can
bench.
be
my-
prepared by anybody on.
Yes.
What is the sanctity of these figures? Some evidentiary value, some supporting document, some your invoices or whatever you prepare. Must support these figures.
My lords, may kindly grant me 2 weeks' time, my lords, I'll file additional affidavit.
Correct.
Please, my lords.
There is no-
Learned advocate, Mr. So-and-so, complainant. Wait for time for 2 weeks. Getting that, he will file additional affidavit supporting the figures of computation of GST claim on VAT contract, which is presently figuring in the tabular form into bracket H page 165 of the compilation of the petition. Stand over to. September, 5th November.
Please, my lords. Next matter, my lords, is also similar.
Similar matter.
Next also
Similar.
same.
Grateful.
Same order next.
Number 47.
Let's My instructions are, the order has been complied with. I may be given a short date to file my affidavit.
15th,
What about
15th of October.
Great.
Number 48. Shant Kumar KC.
Lords, writ appeal has been filed, my lords, on 23/8/2024. FR number is 1292 of 2024. Lord, should may kindly tag along with the writ appeal.
FR number.
FR number is given, my lords, I'll.
Learned.
1307 of 24, my lord, writ appeal number. It is posted for non-compliance office objection on 19th, my lord. There are several office objection is there, my lord, is not yet complied. All the simple matters, my lord.
Writ appeal is filed. They have filed it. Learned additional government advocate, Ms. Pramod stated that against the order brought under the.
After 1 year, we have filed, my lord.
The respondent state has filed writ appeal, which is given FR number 1292 of 2024. And that the writ appeal is filed on 23/8. In that view,
They post along with, my lord, may kindly post along with that writ appeal, my lord.
in this view, learned advocate for the complainant stated that this contempt petition may be posted along with the writ appeal. The request is eminently reasonable. Therefore, both the appeals. You are passing some different order, but you are.
Well, that is, my lord.
Can come when? Which date?
Date.
On which date?
First week of the second, after vacation immediately, my lord.
No, on which date both will come together? Choose the date.
That was the 14th, 15th, my lord.
15th.
Number 49. Harish Shenar.
Paper complaint. But
Order not
request
complied,
for,
not complied.
I request for
Not
2 weeks
complied.
accommodation. But the
The direction is page number 13.
suit was filed, suit was decreed against,
What is
an
that?
appeal was filed by the BDA. That is dismissed for non-prosecution. But the earlier panel advocate, Lord, has been now requested to file an application for recalling in the regular first appeal, Lordship may grant us
Complainant.
2 weeks.
The complaint is senior citizen, 83 years old, my lord.
What is this
That
decree?
suit came to be decreed in my favor.
Decree is for?
Appeal also came to be
Decreed in
dismissed.
his favor to consider his representation under 38C of the BDA Act or to allot an alternate site.
Decree is for what?
Decree for a direction to consider his case under section
Allot
38C.
alternative site.
38C of the Bangalore Development Authority Act, which says, my lord, if the possession vests with the BDA and if the BDA cannot form a layout, my lord,
Page
they'll
number
have
40,
to.
my lord. Page number 40, the operative portion
Then
of the.
you are filing some application for the trial court.
No, my lord, first appeal is filed before this honorable
First
court.
It came to be
And
dismissed. my lord.
appeal came to be dismissed for
Dismissed, my lord.
non-compliance,
Continuous absent.
He says dismissed.
non-prosecution, it was
It
dismissed.
is entire order.
It was dismissed for non-prosecution of the earlier panel advocate, not the revival of
Today,
the
my
panel
my
advocate.
grievance is, my lord, till today, there is no steps is taken to recall the order, my lord. Added to that, there is clear direction by the, my lord, learned single judge. My lord, as
By
per.
virtue of order dated 1st April 24, passed by learned single judge in the petition number 3210 for 24. The respondent commissioner, Bengaluru Development Authority, is directed to consider the representation of the petitioner for compliance of the judgment and decree dated. Decree passed in original suit number 3694 of 2002, which is confirmed in regular first appeal number 1037 of 2016 within stipulated period of 2 months. Full stop. The order of learned single judge still not been complied with. Full stop. In response to the notice, notice in the present proceedings, learned advocate Mr. So and so appeared for the respondent to state that the appeal is dismissed for want of prosecution and that they are moving an application for restoration. Be as it may. Full stop. It is hereby provided that unless the appropriate orders are obtained in the any such application or in regular first appeal within 2 months from today, the respondent shall be liable to comply with the decree passed in civil suit number 3694/2002. Full stop. In the event of non-compliance after 2 months, stern action will follow for the respondent. Please turn over to. November, please.
If I'm permitted to submit, my lord. is the
14th
same-
November is less than 2 months. 27th November.
Please,
Publish.
if I'm permitted to submit, my lord. It's a retired school teacher, my lord. From 2002 is litigating.
Then let him, the remedy is exhausted. We'll then see that it is, something is done.
Serial number 52, Lordship. Matter pursuant to child custody.
Child custody.
Yes, sir.
52.
52. Visitation rights, I've been granted visitation rights.
Your father.
But, I am the father, but it has not been complied. Therefore, I filed, there is shorter date.
Shorter is after.
Senior counsel is engaged.
But the only direction by the family court is that he can see his children through WhatsApp. He's staying in United States of America. The mother has to facilitate a WhatsApp call so that he can see his children. That is the only direction which has been issued.
Time will not,
Family court.
time will not. Here. 30.
Serial number 89, my lords. ADA respondent officials are not in compliance with single bench order, my lord. They are preparing fencing, my lords, and building the compound around the property. According to section 38, they should comply the order, my lords, which was passed in September 12, 2023. 8 weeks time was given, my lords, by the trial single judge, my lord. They have not yet completed even till today, my lords. Only notice may be issued to the respondents, my lords.
Which one?
Serial number 89, my lord.
89, Lord, I make a submission. But I have filed wakala.
Objections are there.
My lords, respondent 4 and 6 are made parties.
In all objections matter, office of shall be complied with within 4 weeks.
There's a council
lord,
submission
serial
to that,
number-
my lords.
68, my lord. Yeah, my land is acquired in 81, my lord. And by a consent order, before the learned single judge, my lord, they have agreed to pay the compensation. And the deputy commissioner, first accused number, has not filed any objection, my lord. Any short date may be given, my lord.
You take appropriate dates after holidays. From the court.
My lord, serial number 59.
Serial number 74. This complaint, the single judge has passed an order. He has retired to give all consequential benefits within 2 months. He has passed an order on 7th December 2023. Still today, they are not complied. Put after MD.
File contempt petition.
My lords.
Contempt.
File it.
Respectful
Permitted to
submission,
file
my-
contempt.
That's one
Permitted
respect-
to file contempt petition.
Contempt and there is.
Contempt, this is contempt.
File.
This is it.
So it is there on board.
453. Serial number 453 of.
Who?
Contempt order.
Serial number is.
Matter is 74.
Mr. Muralidhar,
74.
Mr. Venkatesh, yes, Arabati.
Reopening after holidays.
Contempt order, Shani started.
What is it? Office objection, office. Office, 4 weeks for office.
My lord, serial number 59, my lords. There's some urgencies with respect to recruitments. If a short date could be fixed pursuant to vacations, my lords, I'd be grateful.
Take the date from the court office.
Grateful.